Students are joining. We will start in a minute. Hello, good morning, and welcome to Baiju's Exam Prep. We initiated a discussion on judiciary yesterday. Supreme Court, High Courts, District Courts, and then Gram Nyayalayas. We are focusing on the Supreme Court currently. Constitution says that there shall be a Supreme Court with Chief Justice of India and not more than 7 judges. But Parliament, through an ordinary law passed by simple majority, can increase the number of judges. And today we have a Chief Justice of India and 33 other judges. What is the qualification in order to be appointed as the judge of a Supreme Court? You should be the citizen of India and should have been a judge of one or more high courts for 5 years. If not, citizen of India and the advocate of one or more high courts for 10 years. If not, then the citizen of India, and in the eyes of the president, you should be a distinguished jurist. If these qualifications are met, you can be appointed as the judge of a Supreme Court. To be appointed as the judge of the High Court, you should be the citizen of India and must have held a judicial office for 10 years as the district judge, for example. If not, then you should be the citizen of India and an advocate in one or more high courts for 10 years. If you satisfy these qualifications, you are eligible to be appointed as the judge of a high court. But what is the process? The process is that because of 1993 judgment in the second judge's case, because of 1998 judgment, which is the third judge's case, because of the NJAC judgment of 2015, which is now known as the fourth judge's case. Basis all these judgments, there is something known as the collegium system of judicial appointments, which makes India the only country in the world where basically judges are appointed by themselves. Although the formal appointment order is issued by the president, but the recommendation is given by the judges themselves through a body known as the collegium. Whether collegium is good, bad, or ugly, that's also something that we discussed previously. And the better reform would be to stay with the collegium system, but enhance the memorandum of procedure, ensure that there is no conflict between the executive and judiciary in judicial appointments. Because if there is a conflict, the ultimate loser are we the people. Then we looked at that the seat of the Supreme Court shall be Delhi. The Supreme Court shall sit in Delhi or any other place or places as the Chief Justice of India may from time to time appoint. And for that we discussed, should we have regional benches of the Supreme Court? Or we discussed the suggestion given by former Chief Justice K.G. Balakrishnan, wherein he said that we need to split the jurisdiction of the Supreme Court and split it into a constitutional court and the cassation court. Constitutional court will hear constitutional cases, federal cases, cases involving interpretation of the Constitution. But so far as the cassation courts are concerned, they should be spread across 4 different regions so that they can hear appeals against the judgments given by the high courts. Then we looked at what are the powers, or should we say the jurisdiction of the Supreme Court. All those cases which can be heard only and only by the Supreme Court, we say Supreme Court has the exclusive jurisdiction over such cases. All those cases which can be heard by any other court as well, but can also be directly filed in the Supreme Court, we say Supreme Court has the original jurisdiction on these cases. But obviously there are exceptions. Cases of pre-constitutional era, matters related to the Finance Commission, matters related to the interstate river water disputes under Article 262, those are kept out of the purview of the original jurisdiction of the Supreme Court. There is another jurisdiction of the court which is known as the writ jurisdiction. What is this writ jurisdiction? Under Article 32 of the Constitution, in case of the violation of fundamental rights, one can directly approach the Supreme Court, and Supreme Court will issue various writs such as the habeas corpus, mandamus, prohibition, certiorari, quo warranto, and through these writs, your fundamental rights would be protected. So the power of the Supreme Court to issue writs for the enforcement of the fundamental rights, for the protection of the fundamental rights, because Supreme Court is the protector of the fundamental rights. Those powers are what we call the writ jurisdiction of the Supreme Court. Then we discuss the appellate jurisdiction, that whether it's a civil case or a criminal case or a constitutional case which is heard by a high court, what you can do, you can challenge the verdict of the high court, provided the high court issues a certificate, and through that certificate you can approach the Supreme Court. Appellate jurisdiction, that means these cases are heard by the Supreme Court, but not directly, but through the appeals against the judgments of the high court. And what if the certificate is not provided? A special protection called special leave petition under Article 136. Then we discussed what is the advisory jurisdiction of the court, that under Article 143, Supreme Court acts as the advisor of the President of India. President can refer any matter to the Supreme Court, asking the views of the Supreme Court on this matter. And this matter can be a pre-constitutional matter, where it is mandatory for the Supreme Court to give its advice, or it can be a post-constitutional matter, where the Supreme Court may or may not give its advice. Clear? Any questions? No, yes, maybe. All clear. Why collegium is good, not NJAC? Because in NJAC, yes, there is one issue, the dominance of the executive or the dominance of the other organ of the state. For example, Chief Justice of India, two senior judges of the Supreme Court, they can be vetoed by the two nominated persons, two eminent persons, and the law minister. So any recommendation of the judges can be blocked by the executive, which means then executive will have its say, which means it violates independence of judiciary, which is part of the basic structure. Then what is the only alternative that we have? Collegium system, but with reforms. And reforms can be, sunlight is the best disinfectant. If the question towards the Supreme Court is how you organize these meetings, how you conduct these collegium meetings, how do you come up with a name? Make it clear, put it on your website and tell us that these are the reasons why we are choosing this particular individual. And ultimately people will be convinced that yes, because of merit, because of their credibility, these members have been chosen by the collegium system. Transparency is the key. Okay. Now let's look at the revisory jurisdiction of the Supreme Court. There's a matter which was heard by the High Court. This matter was challenged in the Supreme Court, and Supreme Court has given its verdict. Does that mean this is now the final verdict? Maybe no. Why? Because you can file a review petition against the judgment given by the Supreme Court. Even when this review petition is dismissed, you can file another review petition known as the curative petition. Once that curative petition is also done, the matter is over. How? Let me give you a few examples. Ayodhya case 2019. The dispute was 2.77 acres of land at Ayodhya, where once Babri Masjid stood. Who is the owner of this land? In 2010, the Allahabad High Court, because Ayodhya comes under the jurisdiction of Allahabad High Court, Allahabad High Court gave a verdict where it splits the 2.77 acres of disputed land into three. 1/3 of this land was given to Muslim Waqf Board. 1/3 of this land was given to the Nirmohi Akhara. 1/3 of this land was given to Ram Lalla Virajman, the idol of Lord Ram. This was not acceptable to anybody. All the parties who were involved in this dispute, they approached the Supreme Court. And a 5-judge bench of the Supreme Court in 2019, headed by Chief Justice Ranjan Gogoi, unanimously gave a verdict wherein it said that this 2.77 acres of land will be given to Lord Ram, so that efforts can be made for constructing a mega Ram temple at Ayodhya. But Supreme Court said something else as well. And Supreme Court invoked Article 142 of the Constitution. What is Article 142? Supreme Court can issue any order so as to give complete justice in a particular case, which basically means this. You can't do anything on this matter because you don't have a power. What is this matter? Let's say you have to remove a minister. Can judiciary remove a minister? Ideally, no. Why? Because the job of appointing a minister and removing a minister is with the governor of a state and president of India at the central level. So can judiciary remove a minister? No. Under what power? They don't have a power. Can judiciary protect your fundamental rights? Yes, because that is the power of the judiciary. Under Article 32 for the Supreme Court, Article 226 for the High Court. But in absence of an explicit power, can still judiciary or the Supreme Court specifically do something so as to give justice? Yes, Article 142. How? In anti-defection law case, I told you that Mr. T. Shyam Kumar, who was from the Congress, contested the election, won the election, became the member of the Manipur Legislative Assembly, defected to the BJP, became a minister, forest minister, yet no action was taken against him under the anti-defection law. Matter went to the Supreme Court. Supreme Court gave multiple warnings to the speaker. Take the action, take the action. No action was taken. Supreme Court said enough is enough. We have to do something. But there is no power for Supreme Court to do anything. No explicit power. You can't remove a minister. You can't stop him from attending the Legislative Assembly. You can't ask the speaker, take the action now. Why? Because you have the power of judicial review, which basically means that once the speaker has taken a decision, you can then decide whether the action of the speaker was correct or incorrect, valid or invalid, legal, illegal, constitutional, unconstitutional. But in absence of a given power, explicit power, can Supreme Court still do something for justice? Yes. Invoke Article 142 and you can give any order so as to give complete justice. And under Article 142, the Supreme Court said, Mr. T. Shyam Kumar, you are removed as a minister. In Ayodhya case, when Supreme Court said, all the 5 judges of the Supreme Court said that this 2.77 acres of land belongs to Lord Ram, but then Supreme Court invoked Article 142 so far as to give complete justice and said 5 acres of land at a prominent location at Ayodhya be given to Muslims. Look at it this way. Dispute is on 2.77 acres of land. Clear? If there is a dispute, there is a winner, there is a loser. And if the Supreme Court has said that this 2.77 acres of land belongs to Lord Ram, why should Muslims be given anything? If the dispute was 2.77, why Muslims are given close to double that land, 5 acres of land? What is the logic? You don't have to please everybody. That's the logic. You don't have to please everybody. The judgment has to be clear. You have either won the case or you have lost the case. But Supreme Court invoked Article 142 on what grounds? Saying that in 1949, under the central dome of the Babri Masjid, the idols of Lord Ram were placed. It was previously argued that the idols of Lord Ram mysteriously appeared under the central dome of the Babri Masjid. And the place where these idols appeared, that was considered to be the real birth spot of Lord Ram. The Supreme Court said, no, this was desecration of the mosque. This was basically a violation of the mosque. So basically, Supreme Court is saying that somebody placed the idols of Lord Ram under the central dome of the Babri Masjid. It did not appear mysteriously. So this was an act of desecration. And Muslims lost their mosque when it was demolished in 1992. To undo these wrongs, what we have to do, we have to give complete justice. And that complete justice would be when we will invoke Article 142, we will give 5 acres of land to the Muslims, where if they want, they can construct a mosque. And that too at a prominent location. Supreme Court can give any order so as to give complete justice. That's Article 142. And Article 142 has been used multiple times by the Supreme Court. But once this judgment was given, the Muslim Waqf Board was not satisfied with this verdict. One would be satisfied, other side would not be satisfied, the winner would be satisfied, the loser will not be satisfied. And ultimately, they filed a review petition. This is like you are appearing in a test. 5 descriptive questions are given to you. Now you have written down your answer. Once the answer is written, the teacher evaluates and the teacher says out of 20, you get 8 marks. You quickly run to the teacher, sir, I want to meet you. Ma'am, I want to meet you. Ma'am, you have not marked this question. I have written it. Oh, I forgot to mark this. So you're pointing out an error. Or new facts have emerged. Ma'am, you had asked how many planets do we have? I wrote 8, but you said 9. Pluto is not a planet or Pluto is a planet. A new fact has emerged now. So my answer is right, you are wrong. Under this ground, the teacher will re-evaluate your answer. That's what we call rechecking. In the similar fashion, once the Supreme Court has given the verdict, you can approach the Supreme Court again, saying, dear Supreme Court, please review your verdict. Within how many days can you file this review petition? Within 30 days. So today the judgment is given. You have 30 days to understand this judgment, to read and comprehend this judgment. And then you can file a review petition if you want. But this review petition should be filed on what grounds? Either you have pointed out an error in the judgment, or new facts have emerged in this case, which should alter the judgment. For example, you were declared guilty, that you are guilty, you hang by your neck till death. Why? Because you have committed this murder. Now, after this judgment was given, new fact has emerged. That means the murder weapon which was used in your case that murder weapon belonged to someone else. And we have confiscated that real individual who performed that act of murder. So new facts have emerged. Now you have to place this matter before the same bench who passed the verdict. So same judges who gave this verdict, you will have to approach the same judge, same bench, and tell them that these are the new facts which have emerged. Since you are aware of this case, these are the new facts. Since you are aware of this case, this is the error that we have pointed out. If the court agrees, then the court will hear this matter. If not, then your review petition is dismissed. Even after your review petition is dismissed, you can file another review petition, but this time it is known as the curative petition. And curative petition is something unique in India. How unique? In Hurra versus Hurra, Rupa Ashok Kumar Hurra versus Ashok Kumar Hurra 2000, Supreme Court said finality of justice is important. But it cannot be at the cost of the justice. What is finality of justice? There has to come a point, a time where the case ends. You can't linger on with this case forever and ever and ever. Maybe a case went from a district court to high court, then to Supreme Court, then a review petition. How many review petitions can you file? There has to be an end where we can say finally the case is over. Till 2000, before this judgment, once the Supreme Court has given the verdict, you could have filed a review petition and then the matter is over. The case is dead. In this case, 2000 case, Supreme Court said finality of justice is important, but it cannot be at the cost of the justice. Once your review petition is dismissed, within 30 days, you can file another review petition, because review petition is to be filed within 30 days, and that is known as the curative petition. And what is this curative petition? The success rate of curative petition is less than 1% in India. That means less than 1% of the curative petitions filed, they're accepted by the court. Otherwise, all of them are rejected. Because the grounds on which you have to file curative petition are very, very strong. Strong? Number one, you have to say principles of natural justice have been violated. Bias. Judgment has adversely affected the petitioner. Curative petition, once the review petition is over, dismissed, within 30 days, you can file another review petition, and this is known as the curative petition. But the grounds under which this curative petition is filed are very strong. First, you have to allege and prove it that principles of natural justice have been violated. Maybe the judges did not hear your side of the story when you filed the review petition. Maybe these judges now, they are biased against you. You have to give them arguments why they are biased. And you have to also convince them that this judgment has adversely affected me. Adversely affected would be maybe it was a death penalty, which has adversely affected you, which will adversely affect you. That is why we see in most of the death sentence cases, the curative petitions are filed. But now this time, since the previous review petition was heard by the same judges who heard this matter, now this curative petition will also be heard by the same judges plus two senior judges of the Supreme Court. And then collectively they will decide whether the petitioner is right in alleging bias or violation of the principles of the natural justice, or whether indeed this judgment has adversely affected this individual. But even if this curative petition is dismissed, the case is over. Now, ultimately, finally, we have brought an end to this case. But curative petition is basically a review petition. Review petition is filed within the 30 days of the judgment. So the judgment of the Supreme Court has come today. Within 30 days, you can file a review petition. If your review petition is dismissed today, then you can file another review petition within 30 days. And this another review petition is known as curative petition. But is it necessary to follow this 30-day period? Can you file this curative petition after, let's say, 1 year, 2 years, 3 years, 10 years, 15 years, 20 years? You have to then convince the judiciary why it took you so long to file this curative petition. And is there an instance where this curative petition was filed after many, many, many years? Union Carbide. The Bhopal gas tragedy, which happened, ultimately one factory, Union Carbide, was responsible for lack of diligence, criminal conspiracy, because of which poisonous gases came out of the factory and ultimately led to the loss of lives, destruction in Bhopal. On that basis, compensation was ordered by the court. Union Carbide had to pay millions of dollars in compensation. In 2011, the government approached the Supreme Court again, saying we want to file a curative petition and we want to enhance the compensation that you have awarded. But this year, the Supreme Court dismissed that curative petition, saying we can't reopen this case again. The matter is ended. Long story short, once the judgment is given by the court, you can file a review petition to challenge that verdict within 30 days. If you're still not satisfied, you can file another review petition, which is known as the curative petition. But the grounds on the basis of which you can file review petition is either you point out an error in your judgment or new facts have emerged which previously were not brought before the court. Now, dear court, please look at these new facts. Please look at the error in your judgment and review it. If it is accepted, then the judgment goes in your favor. If it is not, then within 30 days of the rejection of the review petition, you can file another review petition known as the curative petition. But this time the grounds are even stricter. You'll have to tell us that your principles of natural justice have been violated. You have to allege bias and prove it. You have to say and confirm and prove that this judgment has adversely affected you. Then the same judges who heard your review petition will hear your curative petition along with two senior judges of the Supreme Court. And now collectively they will decide what is to be done on this matter. And less than 1% of these curative petitions are accepted, or should I say less than 0.5% of these petitions are accepted. Most of them, majority of them are rejected. Okay. Now let's look at some of the most important contemporary trends in judiciary, and this is where it becomes important for your mains examination. What basically is judicial review? If there is an action of the legislature, now what is the action of the legislature? Legislature can enact a law. What is the action of the executive? Executive does something, for example, creates a policy or denies Aadhaar card to individuals, denies passport to some people, denies beneficiaries their benefits, their claims. So executive is doing something, legislature is doing something. Although they are doing their job, which is within their own domain. Legislature's domain is to make laws. Executive's domain is to implement laws, to make policies, to ensure law and order in the society, to perform foreign policy. These are the jobs and the functions of the executive. And now comes the third organ of the state, which is the judiciary, which keeps a check on these organs to ensure that these organs are within the spirit of the Constitution, so that they do not violate the Constitution, so that they do not violate the rights that are provided under Part 3 of the Constitution. That is what we call judicial review. But judicial review as a concept, as a term, does not find mention in the Constitution. It is undefined in the Constitution. There is no article of the Indian Constitution which explicitly talks about judicial review, saying this action of the legislature, this action of the executive can be reviewed by the judiciary. But we can trace this concept of judicial review to Article 13, Article 32, 226 of the Constitution. Article 13, Clause 2. The state shall not make any law to delete, modify, abridge a fundamental right. And such a law, to the extent of that contravention, will be declared null and void. And we assume that it will be declared null and void by the judiciary. That is where we derive the power of judicial review. Or Article 32 and Article 226. If your fundamental rights are violated, you can approach the Supreme Court under Article 32, High Courts under Article 226. And these High Courts and the Supreme Court will issue various writs. And through these writs, your fundamental rights shall be protected, preserved, guaranteed. What is that? That is judicial review. And Supreme Court has said that judicial review in Minerva Mills 1980, Supreme Court has said judicial review is part of the basic structure of the Constitution, which means any law which violates judicial review, which deprives judicial review, which does away with judicial review, will be unconstitutional. That is why in anti-defection law, for example, when the Constitution said under the 10th schedule that the decision under disqualification shall be taken by the Speaker and the decision of the Speaker shall be final and binding. In Kyoto Holohan 1992, Supreme Court said this provision is unconstitutional. Why? Because it snatches the power of judicial review by saying the role of the Speaker is final. The decision of the Speaker is final. No other organ can give a final verdict except the judiciary, because judicial review is part of the basic structure of the Constitution. But when the judiciary, Supreme Court, for example, is practicing judicial review, listen to me carefully. When this judiciary, Supreme Court, for example, is exercising this power of judicial review, is it reluctant to declare the law unconstitutional? Is it reluctant to declare the actions of the executive unconstitutional? Does it give a benefit of doubt to executive and the legislature? Or should we say, is the judiciary very restrained in its power, in using its power, and says, no, unless and until you convincingly prove me that legislature is wrong, executive is wrong, I will not interfere, I will not declare their acts unconstitutional. That is what we call judicial restraint. That means judiciary is restraining itself from interfering with the other organ of the state. Unless and until blatant violation of the Constitution is done by executive and the legislature, judiciary will not declare their laws or actions unconstitutional. Judiciary will exercise restraint. But then if judiciary does not exercise restraint, it is very eager, it is very proactive In declaring the laws passed by the legislature and the actions of the executive as unconstitutional, we say judiciary is practicing something called judicial activism. And judiciary is practicing this judicial activism through an innovative tool known as PIL, public interest litigation. And what is this judicial review? Sometimes the definitions are asked. You will scramble for a definition. That's why I've mentioned definition of these terms here itself. Power of the courts of a country to examine the actions of the legislative, executive, and administrative arms of the government and to determine whether such actions are consistent with the Constitution. Actions judged inconsistent are declared unconstitutional and therefore null and void. The institution of judicial review in this sense depends upon the existence of a written constitution. What is the role of judiciary in Britain? It has a very limited power. Because British Parliament is sovereign, it can do anything. That means in countries where the constitution is written, judiciary has a power. Judiciary has more power, such as United States, such as India. That is judicial review. But now that you have understood what judicial review is, what is this judicial restraint that I was talking about? 1951, Shankari Prasad. Article 31 capital A, Article 31 capital B, 9th schedule of the Constitution were challenged in the Supreme Court. Supreme Court said, no, the legislature is right. This is not the violation of the Constitution. That means judiciary is doing what? Exercising restraint. Unless and until you prove it explicitly that there is blatant violation of Constitution, blatant violation of the fundamental rights, we will not interfere and we will ensure that the laws passed by the Parliament are okay. That is what we call presumption of constitutionality. What is this presumption of constitutionality? When the laws are passed by the Parliament, they are challenged before the Supreme Court. Who will challenge? For example, you are the citizen of India. You are challenging this law, for example, Citizenship Amendment Act, before the Supreme Court. The Supreme Court will assume that this law is constitutional. That means now you have to prove me why this law is unconstitutional. That means the burden is on you to convince me that this law is unconstitutional. That's what we call presumption of constitutionality. So here judiciary is exercising restraint. Restraint in the sense you are walking on the road and suddenly there is a motorbike which hits you. And now this motorcyclist gets down and then starts slapping you. You're not reacting, you're exercising restraint. He's pushing you, slapping you. You know you're not at fault, but still you're exercising restraint because you know the moment I lift my hand, this man is gone. You're exercising restraint. Similarly, judiciary. Laws are passed, actions are taken by the executive, but judiciary, whenever it is challenged before the judiciary, it is exercising restraint, saying unless and until you prove it convincingly that this law is unconstitutional, I'm not going to strike it down. It is only when that motorcyclist starts abusing you, you lose your mind, one punch and that person is gone. That one punch or that abuse is when you convincingly prove the judiciary that this law is blatantly unconstitutional. Otherwise, judiciary will exercise restraint. Shankari Prasad Dev, Supreme Court said 31A, 31B, 9th schedule, constitutional. Similarly, we saw Gopalan case. where the government would send its officers and will frisk the house of people as well, even if it is during the night, because we assume that you are doing something international. A.K. Gopalan, Supreme Court, was told that my privacy is getting violated. How can you frisk my house? That too in the middle of the night. Supreme Court said you don't have right to privacy. Right to privacy is not a fundamental right. And we follow something known as procedure established by law. If law is there and executive is taking actions according to that law, we cannot protect you. You cannot challenge the law on the ground that it is not fair, it's not reasonable, it's not justified. That's something that you can't do. That means judiciary initially was exercising restraint. And it has two approaches, a procedural approach and a substantive approach. What is the procedural approach? It urges the judges to refrain from deciding legal issues, especially constitutional ones, unless the decision is necessary to the resolution of concrete dispute between adverse parties. There are two parties to a particular case. Decide which party is right, which party is wrong, without going into constitutionality. So you could have said in Hadia case, which we discussed yesterday, whether this marriage is legal or illegal, without getting into and innovating that right to marry is a fundamental right under Article 21. Don't go that route. Just look at this dispute, whether this marriage is legal or illegal. If there are two consenting adults, both have given their consent, both are with sound mind, they've decided to marry, just say this marriage is valid or this marriage is invalid because of these reasons, without going into right to marry is a fundamental right. You don't have to do that. Exercise restraint. Just stick to this question without deviating from the point of question in hand. And a substantive one, principle and presumption of constitutionality. After all, legislature is elected by the people. They are accountable to the public. If they will pass a bad law, let people take care of it. Let people vote them out of power. At least give them some respect. Assume that they are doing something right for the welfare of the people. Don't come up with this preconceived notion that all these legislators are crooks, thieves. Give respect to them. That is judicial restraint. That means judicial review is, judiciary will review the actions of the legislature. That means the laws passed by the legislature. Judiciary has the power to review the actions of the executive. That is judicial review. But while practicing this judicial review, will judiciary be restrained or judiciary will be arrogant? Restraint is just focus on what the question is asking. Don't go into unnecessary details. And that is something we can suggest you when you are writing your mains answers. Write to the point answers. Don't beat around the bush. Whatever you are being asked, only write that. For example, the question is, what is judicial review? You can't start with that the seat of the Supreme Court shall be in Delhi and it can sit at such other places or place as the Chief Justice from time to time with the approval of the President appoint. We have the Supreme Court with one Chief Justice, 33 other judges. These are the original powers. These are the exclusive powers. This is how the judge is appointed. This is how the judge is removed. And at the end, you will write one small paragraph. This is judicial review. You will get 0. And then you will file rechecking. Please, why are you giving me 0? I'm not satisfied with. I wrote 7 pages of answer. I don't need that. Just tell me what is judicial review. Without beating around the bush, without giving me unnecessary details. So if there is a case in hand, just stick to this. Don't go somewhere else. If the case is that whether this marriage is legal or illegal, just decide on that legality. Don't take another route and say marriage is a fundamental right. Clear? Or judiciary exercising restraint by assuming that this law is constitutional. It's for the petitioner to prove that this law is unconstitutional and give respect to the views of the legislature. They are, after all, elected by the people. They are accountable to them. That is judicial review. And that is how, in the initial years of our republic, from 1950s onwards, in majority of the cases, judiciary was exercising restraint. But over a period of time, it turned into activism. And what is this judicial activism? An approach to the exercise of judicial review. That means you have to exercise judicial review. Either you will be restrained or you will be an activist. Judicial activism, or a description of a particular judicial decision in which the judge is generally considered more willing to decide constitutional issues and to invalidate legislative or executive actions. Previously, the judiciary was restrained. It was not willing to declare the law passed by the parliament or the actions of the executive as unconstitutional unless and until you convincingly prove it. For example, in murder cases, all the evidence is against me, but there is still some room for doubt. I cannot be punished. I can be punished for murder if it is proven beyond any reasonable doubt that yes, you are the murderer. That is why previously what would happen, there used to be something known as jury system, which thankfully has now been abolished. What is this jury system? For example, here is a judge, and then there is a jury. These are people from different walks of life, common people, people like you and me, who have been selected, who have been chosen for this particular case. These may be 5, 6, or 10 people, part of the jury. Commoners, not judges. If there is a case involving murder, for example, A has murdered B. Now there is a case. You have to convince the jury. And how do you convince the jury? Not through legal jargons, not through legal language. You have to give them a situation and say and convince them and try to convince them that I could not have committed this murder. And whatever action, whatever decision jury takes by majority, that will be the verdict. So instead of judges deciding whether you are guilty or not, it is the jury which decides. Common people who will decide by looking and hearing your story, hearing the story of the opposite party, and then they will have to decide who is right or wrong, which may not entirely be correct. You can fool them as well, but that was the system previously. But judicial restraint was unless and until you prove beyond any reasonable doubt that this law is unconstitutional, this action of the executive is unconstitutional, judiciary will exercise restraint and not declare them unconstitutional. But over a period of time, judiciary became an activist. Judicial activism, where the judges are more willing to decide on constitutional matters and invalidate the actions of the legislature or the executive. And one tool which was used for this judicial activism was public interest litigation. What is the origin of this public interest litigation? Kapila Hingorani. A lawyer. She was reading newspapers, and ultimately she came across few news articles where it was found that the condition of under trials in Bihar is bad. Who is an under trial? For example, you are accused of a crime for which the case is going on, but you are in jail, or you are on bail, but you are on under trial. That means you are under trial. Whether the court declares you guilty or not, that remains to be seen. If the court declares you guilty, you are convicted. If the court sets you free, you are a free bird. But right now, you are under trial. And these newspaper articles spoke of the conditions of under trials who were languishing in Bihar jails. If you are a wealthy, connected individual, you are an under trial, there is a case pending against you, there is a trial going on to declare whether you are guilty or innocent. But since you have money, you are a connected individual, you are out on bail. You're not in jail, you're out on bail. You are cooperating with the investigation, you attend the court proceedings, but you are still not inside the jail. But those who cannot afford bail, because for that you have to give some surety. Those who cannot afford bail, those who cannot afford lawyer to grant them the bail, they are languishing in the jails. And the condition of under trials in Bihar was such that there were under trials who served in jail as under trials for more years than the maximum punishment for the offense they were accused of. Look at the irony. I am accused of theft. You are also accused of theft. Police has filed the FIR. Charge sheet is now filed in the court. That means this charge sheet lists everything, all the evidence against you, me. But I ask for bail. The bail is given to me. I'm not in jail. I'm out on bail. I cooperate with the investigation. I attend the court proceedings as well. And the court will give me tariq pe tariq pe tariq, and the case will continue for decades. That means during all this 2-decade period or 10-year period or 5-year period when the case is going on, I'm an under trial. But you are from marginalized section of the society or poor or not connected. You can't arrange a lawyer for your bail. And ultimately the court is not granting you bail. You are inside the jail. That means you are an under trial, but you are in jail. You're not yet convicted, but you are in jail. And if you are convicted for an offense for which maximum punishment was 5 years, you are serving time in Bihar jails as an under trial for 7 years, 8 years. What does that mean? Number one, the golden rule of criminal justice system is you are innocent until proven otherwise. You are innocent until you are declared guilty. That means it is for the police to convince the court that you are guilty. Otherwise, you are innocent. What if you are indeed innocent? How many years are you rotting in the jail as an under trial? 8 years. Even if you are guilty, what is the maximum punishment that can be awarded to you? 5 years. That means number one, we don't know whether you are guilty or not. You are still serving more number of years in jail than the maximum punishment if you were convicted. That means even if you were convicted, by now you should have been released. It would be 3 years since your release. You are serving more time in the jail as an under trial than if you were convicted for the offense you were accused of. And maybe you were not given maximum punishment. Maximum punishment is 5 years. Maybe the court would have said, if your case indeed would have been solved quicker, maybe the court would have said you are sentenced to 2 years in jail. We are saying even if you are sentenced to maximum number of years as the punishment for your offense, by now you would have been released. Kapil Hangorani saw this. She approached the Supreme Court. And there were 2 judges of the Supreme Court who heard this matter. Justice Bhagwati, Justice Krishna Iyer. And I've told you about Justice V.R. Krishna Iyer. Maybe I did. I know that, but I don't know whether you remember or not. Justice V.R. Krishna Iyer was a minister under EMS Namboodiripad government in Kerala. When that government was dismissed, Mr. V.R. Krishna Iyer went back to bar, practiced law, was appointed as the judge of the Kerala High Court, then got appointed to the Supreme Court as well. And he is the one, along with Justice Bhagwati, who is responsible for introducing public interest litigation in India. Justice Bhagwati Unfortunately, fortunately known for a lot of good things, but unfortunately known for something sorry as well. And what is that? Is that important? Not important? That's not important, so let's leave it. Justice Bhagwati, Justice V.R. Krishna Iyer, they heard this matter. The beauty about this is the judges did not ask for locus standi. Normally, if you are an agreed individual, if your rights have been violated, you can approach the court. Kapila Hingorani is not connected with these under trials in Bihar. So she does not have the locus standi, which basically means she is not the family member or the lawyer of these under trials. So how can she approach the court? But when Kapila Hingorani presented all these matters before the Supreme Court did not ask, who are you? How are you connected with this case? Supreme Court said, you are a public spirited individual. You're not approaching us for your own personal interest. You're approaching us for the larger public interest. And larger public interest, where for weaker, marginalized sections of the society, their fundamental rights are affected. Their fundamental rights are concerned. Their fundamental rights are violated. Supreme Court said this is what is public interest litigation. That means an individual approaching us, not for his or her personal interest, but for the larger public interest, when their fundamental rights are concerned, their fundamental rights are affected, we will not ask you what is your locus standi, how are you connected with this case, how are you concerned with this case. And Supreme Court ordered the release of 40,000 under trials in Bihar and other jails in India. And that led to the birth of public interest litigation in India. After the success of this public interest litigation, now there were NGOs who decided to approach the court on behalf of street vendors. Because there are two problems in India. One is judicial literacy, which is very poor. People are literate, but not literate about or educated about their rights. With hand on your heart, you tell me, before you started attending these classes or before you started preparing for the civil services exam, were you aware of the rights that you have, that you enjoy under the Constitution? Most of you would not be. Now you become aware. So imagine we have poor, weaker sections of the society who are not literate, who are not educated. How would they be educated and literate about the rights that they have? If somebody is forcefully evicting them, they don't know that they have a right that they can approach the court and the courts will protect them. Or even if they are aware, they can't hire a top lawyer and pay them lakhs of rupees so that through these lawyers they can get justice. This is where non-governmental organizations come into the picture. Non-governmental organizations approach the Supreme Court or High Court on behalf of marginalized, weaker sections of the society when their fundamental rights are violated, but they cannot approach on their own. They approach through their NGOs. NGOs approach them, or common individuals approach them for the larger public interest. That is public interest litigation. There were professors from Delhi University who visited Agra. There was a reform home for women in Agra. And they saw that women are being sexually harassed, molested in this Agra home. They wrote it in the newspapers because they were conducting a survey. A judge read this newspaper report. Nobody approached the Supreme Court. Nobody approached the High Court. Nobody approached the judge. The judge is only reading a newspaper and is converting this newspaper article into a petition. And that is what we call Supreme Court acting suo motu. Normally, somebody approaches the court. You have to approach the court and then decide. Then the court will decide whether you are guilty or not, whether action should be taken or action should not be taken. But what if you don't approach the court? How will court come to know? For example, you are in the classroom and suddenly there is a fight between the two students in the class. One is abusing the other, one is shouting at the other, one is slapping the other, and there's a brawl involved as well. Now, one of the student has to approach the teacher or the principal saying this person or this student has done this, that, and that, and now please take an action. Now, if the student is not approaching, then what do? This is where the Supreme Court says, or the high courts can take the matter suo motu on its own. Without somebody approaching it, the courts can take the matter on their own. For example, Amarnath Yatra was going on, and suddenly there were unfortunate deaths of the Yatris because facilities were not provided to them. Medical facilities were absent or redundant along the route of the Amarnath Yatra. This matter was picked by the newspaper. The judge was reading this matter. Judge said this is public interest litigation. Somebody is approaching us through newspaper. That means Supreme Court took the matter on its own, issued directive to the government to provide medical facilities to those yatris who are going on the Amarnath Yatra. Suo motu, Supreme Court or high courts acting on their own for the larger public interest. That is public interest litigation. And this public interest litigation has had a lot of significance. For example, it is through this public interest litigation that Supreme Court has expanded the scope of Article 19(1)(a). Supreme Court has expanded the scope of Article 21. Public interest litigation was filed and Supreme Court said right to health is a fundamental right. Right to clean environment is a fundamental right. Flying a national flag is your fundamental right. It's part of your freedom of speech and expression. That means it is through this route of public interest litigation that Supreme Court expanded the scope of Article 19, Article 21, and gave us fundamental rights which originally were not part of the Constitution. That was the significance. But if the question is asking you, what is the significance of the public interest litigation? These are the points that you can mention. The aim of the PIL is to give common people access to the courts to obtain legal redress. Common people who are not judicially literate, they don't know, they are not aware of their rights. Now, when somebody is approaching the court on their behalf, they get justice. That means the aim of the public interest litigation is to give common people access to justice through public interest litigation. PIL is an important instrument of social change and for maintaining the rule of law and accelerating the balance between law and justice. Social change. Through the concept of public interest litigation, we have created a structure in place where rights are provided to those people who were not aware of their rights. Through public interest litigation, we have expanded the scope of fundamental rights. And through public interest litigation, we have also created a society where there has been some elements of change. Transgenders, whether they should be recognized or not, society would not have recognized unless and until a PIL was filed. Law may not change the society, but law may facilitate a change in the society. Public interest litigation purpose was to make justice accessible to poor and the marginalized sections of the society who can't afford lawyer who can fight their cases on their behalf. It is an important tool to make human rights reach those who have been denied rights. For example, there is eviction going on. There is a piece of land which was occupied by citizens illegally. Let's agree, it was illegal occupation of the government land. But these are the people who have been residing on this piece of land for decades. Now, where will they go? Is it not the responsibility of the state to protect them? Now, if the state wants to throw them out, there are NGOs, there are public spirited individuals who approached the court file a public interest litigation. My lord, please stop this eviction and provide them alternate arrangements. Rehabilitate them, then you can evict them from their government land. That is public interest litigation. It democratizes the access of justice to all. Now anybody can approach the court for the larger public interest. Any citizen or organization who is capable to file petitions on behalf of those who cannot and do not have the means to do that. Public interest litigation for the larger public interest. It helps judicial monitoring of state institutions like prisons, asylums, protective homes, etc. For example, when those letters were written, when the articles were written alleging torture, sexual harassment and molestation of women at Agra Reform Home, when this matter reached the court, the Supreme Court directed that we will monitor these reform homes. We will send our judge to look into the condition of women in these reform homes. Imagine a situation. That's not the job of the court to monitor reform homes or prisons. That's the job of the executive. But when executive is failing in its duty, judiciary comes into the picture and now starts reviewing the actions of the prisons. It is an important tool for implementing the concept of judicial review. It has enhanced public participation in judicial review, and ultimately, over a period of time, more and more lakhs and lakhs of public interest litigations have been filed. Long story short, judicial review. We know that when the judiciary is practicing judicial review, either it will be restrained in its actions unless and until there is blatant unconstitutionality, or judiciary will be very willing to declare laws passed by the parliament or actions of the executive unconstitutional. Judicial activism. And judicial activism is practiced through this concept of PIL. And what is this PIL? Somebody approaching the court on behalf of the larger public interest. They don't have personal interest, they have public interest in mind. And ultimately, they try and convince the court to expand fundamental rights, to give justice to the poor, to ensure that executive and legislature is doing its job. That is judicial activism practiced through public interest litigation. But the concept was very novel. Concept was pure, with the right intention. But over a period of time, this public interest litigation has morphed into personal interest litigation, or should we say publicity interest litigation. What is this personal interest? There was a poet, he's still alive, there's a poet in Srinagar. He filed a public interest litigation in Jammu and Kashmir High Court. On what grounds? The ground was that the government had decided to construct a flyover which was next to a prominent school in Srinagar. His concern was that if this flyover is constructed, then what will happen? The security of the students will be jeopardized. Their lives would be in danger because then they would cross the road. They may be hit by a car. We should not have a flyover there. When he approached the court was initially very happy. Thank you, dear poet, for approaching us. You have taken time to approach us, not for your own personal benefit, but for the benefit of the larger society, for the students. You're taking time, that is even more important. But whenever these public interest litigations are filed, in some cases, the courts appoint amicus curiae. Who is this amicus curiae? Friend of the court. That means normally when a petition is filed in the court, there is one lawyer who is against, there is one lawyer who is pro. That means if this is a murder trial and you are an accused, there will be one lawyer who will say you are accused, you are guilty. There will be your own lawyer who will try to defend you and say you are not guilty, you are innocent. That means there are always two opposing sides. When this public interest litigation was filed, that this construction of the road or the flyover should be stopped because it will affect the safety of the school going children. The court asked one senior lawyer, please assist us in this case. Make us reach the conclusion. Be the friend of the court, amicus curiae. A senior lawyer is asked to assist the court. But when this amicus curiae digged deep into this, he realized that this is personal interest morphed into public interest. The amicus curiae told the judges that this particular poet has a land which is next to the school. And if a flyover is constructed, then because of that flyover, there will be no privacy for that land. The value of that land will reduce. So he is approaching you on behalf of the students, but in reality, it is his personal interest which is taking him to the court. The court said, we thought you are somebody, now you are someone else, 20,000 fine on you. And if you do this again, if you approach us with public interest litigations, but basically these are personal interest litigations, we are going to take action against you. 20,000 fine, get lost. That's not the only problem. The problem is you are then wasting the time of the court. There are lakhs and lakhs of cases pending. Whenever a public interest litigation is filed, they get precedence. They get preference. That means we have to stop what we are doing. We have to hear these public interest litigations. If these are not public interest, these are private interest litigations. One, you are violating the sanctity of this PIL. Two, you are wasting the time of the court. Sometimes not personal interest, but sometimes publicity as well. You approach the court. Why? Because if you file a petition which catches eyeballs, you will come on an Arnab Goswami show, or you will be interviewed by the newspapers and news channels, and suddenly you are a celebrity. Everybody knows who you are. A PIL was filed in the Delhi High Court saying the Prime Minister of India's Facebook page shows a distorted picture of the national flag. Why? You want publicity. Case filed against Prime Minister's Facebook page. The nation wants to know. Waste the time of the court and you get the publicity as well. Which means tomorrow judiciary will be reluctant to accept these public interest litigations, saying all of them are personal interest or publicity. PIL was filed against rapper Yo-Yo Honey Singh in Punjab and Haryana High Court for offensive and vulgar lyrics of his various songs. If you don't like his songs, don't listen. I don't listen to his songs, but that doesn't mean I want to ban his songs. But since you are filing a petition against Yo-Yo Honey Singh, Yo-Yo, you are very famous. A public interest litigation was filed against Bollywood film Jism 2 for promoting a call girl which featured ex-porn star Sunny Leone. Just before a movie is about to be released, you will see public interest litigations filed that this song is vulgar, this concept is bad, you are going to corrupt the young minds. So I am a public spirited individual. For the larger public interest, I am telling the court, please ban this movie. Why? Because this movie promotes an ex-porn star, which is going to corrupt our young minds. No, it is corrupting your mind. How dare you? Don't want to watch the movie? Don't watch it. Don't waste the time of the court. You are here because you need publicity. So that Friday, when this movie will be released, alongside you will also be interviewed by the newspapers and channels. And over a period of time, so many interesting public interest litigations have been filed, which will tell us that it is not public interest, it is publicity interest. PIL was filed against a song in a movie Shanghai, which said, Sone ki chidiya, dengue, malaria, good bhi hai, gobar bhi, Bharat Mata ki jai. It is offensive to Bharat Mata. Public interest litigation was filed. Public interest litigation was filed against the song, which suddenly became viral. Why this Kolavari D? Why this Kolavari D? But why this PILD? Publicity. A public interest litigation was filed in Allahabad High Court. It requested the court to direct the shops selling women undergarments should be restricted from improper display of undergarments. So you should not use female busts which display the undergarments of women because this corrupts the young minds. Can't say much. So public interest litigation has its own significance as well. But over a period of time, it has morphed into publicity interest or personal interest litigation. How do we solve it? For that, rules were made, guidelines were made by the Supreme Court. Guidelines number 1, the courts should verify the credential of the petitioner. That means now whenever you file a public interest litigation, this matter goes to the court. The court will, before placing this matter before the judges, will look into and verify the credentials of the petitioner. Who is this petitioner? Is this petitioner seeking publicity or is genuinely interested in public interest? If not, then we will dismiss. This PIL will not reach the desk of the judges so that we can save the time of the judiciary. Substantial public interest should be involved. Substantial public interest. Previously, PILs were filed when somebody would not get pension. I, as an individual, I am eligible for the pension, but I am not getting pension. You can still approach the court, but not through PIL, through writ petition. You can approach the High Court and file a writ petition under Article 226. Or you can approach the Supreme Court later under Article 32 if your fundamental rights are violated. But it cannot be a public interest litigation because you are one individual. One individual cannot be treated as public interest. Similarly, petitions involving larger public interest, gravity and urgency must be given priority. That means if there is a huge list of PIL, but those which involve, let's say, eviction of people from their homes, it requires urgent attention. If there is a PIL which talks about that drinking water has not been given to this village since independence, and this village is basically dominated by the Dalits, so it is through deliberate action that you are not providing drinking water to this village. It requires urgent attention because we are talking about larger public interest involved. That is public interest litigation. And judicial review or judicial activism, basically, it signifies the anxiety of the courts to find out an appropriate remedy for the aggrieved person by formulating a new rule to settle the conflicting questions in the event of uncertain laws or absence of any law on a given point. New rule if the law is not clear or if there is no law. Anxiety of the court. Somehow we have to provide justice in this case. Example. Vishaka guidelines. One lady, Bamri Devi, she was an Anganwadi worker. She was a public employee as well. And she was tasked by the government that you do one thing, you promote, you create an awareness that child marriage is illegal and child marriage should not be allowed. Bamri Devi, she went from village to village and tried to convince the people in Rajasthan that you should not opt for child marriages. But that was the season when child marriages were at its peak. Suddenly what happened? 5 men were there who allegedly raped Bamri Devi. I'll say alleged because it was not proven later. Bamri Devi was raped, allegedly raped by 5 men. Matter went to the court. 5 individuals were arrested, but the court set all of them free. Why? Horrible argument was given by the court. One, the court said when Bamri Devi was raped, who was the other individual present? Who saw Bamri Devi being raped? The husband of Bamri Devi. But we can't buy this, that she was raped. Because if she was raped or she was being raped, husband would not sit like that. He would do something to stop this rape and will fight out these 5 people. So we cannot imagine and anticipate a situation where Bamri Devi was being raped by 5 men and the husband did nothing, he was just watching. That means the rape did not happen. Other argument given by the court was that two of these accused, one is the uncle, the other is the nephew. Under Indian Sanskriti, under Indian culture, we cannot imagine a situation where uncle is performing a sexual act or raping somebody in presence of his nephew, or nephew doing this in presence of his uncle. That is why we think that this rape never happened. And all the accused were set free. But matter went to the Supreme Court. Not because of Bamri Devi, not for Bamri Devi, but for every Bamri Devi. She was doing her job and she was harassed at a workplace. What are the guidelines for preventing sexual harassment of women at workplaces? Harassment is of multiple kinds. I'm telling my colleagues, do you know why this girl was promoted? You know why she was promoted. Why that boy was promoted? Because of his talent. But why she was promoted? We know the reason. Innuendos, aspersions are casted on her character. The length of her skirt determines whether she will be promoted or not. Vulgar comments are being made. And she's being harassed. And ultimately, you may not even understand, but she will be under horrible situation over a period of time. Her mental framework would disappear and she may want to come out of workplace and resign from the job. And then how are we going to have diversity in our workplaces? How are we going to give justice to the second gender? But there is no law which prevents sexual harassment of women at workplaces. Supreme Court said, don't worry. We will lay down Vishaka guidelines, and these guidelines would prevent sexual harassment of women at workplace. So what is judiciary doing? Judiciary is doing something which was till then unimaginable. What was that? Judicial legislation. Judicial legislation as a term can be oxymoron. That means these are two terms are not compatible with each other. The job of the judiciary is not to legislate. The job of the legislature is not to give judicial judgment. But now this is a law which is passed by judiciary, which goes against the separation of powers. But judiciary is helpless. It can't do anything because legislature is not doing its job. Legislature should have enacted a law which would prevent the sexual harassment of women at workplace. If you're not passing that law, what do? We are left with no other choice. But under Article 141 of the Constitution, any judgment that we give will be same as that of the law passed by the Parliament. Judicial legislation, which is against separation of powers, but judiciary can't help, and we can't help. We go to the judiciary when the executive or legislature is not doing its job. Lingdo Committee recommendations. Matter went to the court. What's the matter? Sir, do you know what is happening in our universities and colleges? There are student unions. Yes, these student unions are affiliated to various political parties. National Students Union of India to Congress, Akhil Bharati Vidyarthi Parishad to the BJP, ABVP. There are others. So many other student unions affiliated to various political parties. So what? Sir, they use money power, muscle power to contest student elections. And some of these leaders, so-called leaders who contest elections, they're not there to study in university. They are primarily taking admission to contest elections. So that once you become the student leader, you get quick access to the political parties, and now you become the MLA or the MP and later on chief minister. So that is how Lalu Yadav, that is how Arun Jaitley, Ravi Shankar Prasad, and various other individuals have emerged in India from student politics. But how can you say that these so-called leaders, they take admission only to contest elections, not to study? So look at their attendance. They don't attend the classes. So look at their percentage in the examination. They are failing in the examination. So their interest is not to seek education. Their interest is not to pass the examination. Their interest is politics. So for that reason only they take the admission. Yes, you're right. And then they bring in a lot of money. They corrupt the student life. They bring a lot of gundas who threaten the people, who threaten the students that you vote for us, otherwise we will kill you. Stuff like that. Supreme Court said, why is Parliament silent on this? Why is executive silent on this? Why are they not making rules to ensure that there is less money power, muscle power, and such people, only talented individual, only those who are genuine students should be able to contest elections? How can they do it? Because they have the self-interest, their own leaders, they have student unions affiliated to them. So don't worry. Mr. J.M. Lingdo, come here. Meet J.M. Lingdo. He was the former Chief Election Commissioner. Please, you do one thing. You lay down guidelines about student elections in India. But sir, that should not be your job. That's the job of the executive or the legislature. But they are failing to discharge their duty. When they fail to discharge their duty, now we have the anxiety. We have the anxiety to interfere in this matter. You lay down guidelines, and these guidelines would be judicial legislation. And that is how we will decide how student elections should be conducted. And Lingdo committee recommendation said your attendance should be more than 75%. You should not have had a backlog in your examination. This is the amount of money that you can spend. You can contest election only for one term. After that, you cannot contest the election, so that others get the opportunity. To ensure that money power, muscle power is eradicated, only the students are able to contest elections, not the outsiders who hijack these student unions. Lingdo committee recommendations were made. But that is not the job of the judiciary. But judiciary is still doing this. Why? Because judiciary is now an activist who is performing this duty because the legislature or the executive has failed to discharge its duty. This is judicial activism. Similarly, removal of Loka Yukta, not the removal, the appointment of Loka Yukta in UP. Loka Yukta is to be appointed by the governor on the recommendations of a committee. Chief Minister Akhilesh Yadav is giving a list. Governor is not accepting that list. So there is no consensus between governor and the chief minister. There's a tussle between the governor and the chief minister. But we need a Loka Yukta in UP. A public interest litigation was filed. Dear Supreme Court, please look into this. We don't have a Loka Yukta in UP. The Supreme Court asked the government of UP, what's the matter? Said, we gave 4 names to the governor. Governor is not accepting. Governor, what's the matter? I'm looking into it. There is no consensus. I want some other individuals. Ongoing bickering continues. Supreme Court at one point said, enough is enough. We are invoking Article 142 of the Constitution to give complete justice. We can't function without the Loka Yukta, because it is this Loka Yukta who will be responsible for investigating corruption allegations against the chief minister, against his ministers, against the bureaucrats. In absence of that Loka Yukta, we see a vacuum. This vacuum needs to be filled. And if you're not filling this vacuum, then ultimately we have no other option but to become the activist. We are invoking Article 142. We will appoint Loka Yukta in Uttar Pradesh. That's the job of the government. That's the job of the executive. But why is Supreme Court getting involved in this? Because there is anxiety. When the legislature is failing to discharge its duty, when the executive is failing to discharge its duty for the larger public interest, it is the job of the Supreme Court to enter into the picture and take the role of an activist and provide justice to the people. That is what we call judicial activism. But there is a thin line between judicial activism and judicial overreach. Subramanya is asking, give definition of judicial activism in simple words. This, my dear, is judicial activism. Judicial activism is an approach of judicial review or a description of a particular judicial decision. That this decision is judicial activism, in which a judge is generally considered more willing to decide constitutional issues and to invalidate legislative or executive actions. Or in other words, the expression judicial activism signifies the anxiety of the courts to find out an appropriate remedy. What is the remedy? Lindo Commission recommendations. What is the remedy? Vishaka guidelines. For those agreed individuals, by formulating a new rule when the existing laws are uncertain or there is no such law. There is no such law to control money and muscle power in student elections. There is no existing law to prevent sexual harassment of women at workplaces. At least it was not existent in 1997 when Vishaka guidelines were passed. And it was only in 2013 that the Parliament enacted Prevention of Sexual Harassment of Women at Workplaces Act. But there is a thin line between judicial activism and judicial overreach. What is judicial activism to you may be judicial overreach for someone else. This is subjective. And if it indeed is judicial overreach, it violates separation of powers. And this separation of powers is part of the basic structure of the Constitution. Who said this? Supreme Court, not us. One example of judicial activism was where you're genuinely caring for the people was 1980 Bhagalpur blindings, where if you have watched that beautiful movie by director Prakash Jha starring Ajay Devgan, Gangajal, it was loosely based on 1980 Bhagalpur blindings, where there were rapists, there were murderers, there were criminals, there were thugs, but they would get bails and they would then commit public nuisance as well. The police decided to use the acid, pour this acid into the eyes of these criminals and blinded them. Now they can't commit the crime. So if the job of the police is to prevent crime or to control crime, the easiest way is kill the criminals or blind them. But you can't be taking law in your own hands. This is torture. Playing its role in protecting the rights of the people, because including those criminals, they also have rights. What if I'm only an accused? I'm not a criminal. I'm only accused of a crime. If such a thing is allowed to continue, tomorrow anybody can accuse me of a crime, and what the police will have to do, pour acid into my eyes. But I'm only accused. I'm not a guilty person. I'm innocent until proven otherwise. This would lead to mob justice. And that is unfortunately what is happening currently in some places. Just an allegation that a beef was stored or beef was cooked, a group of people would come and burn down that house. Just an allegation that this person is involved in an illicit relationship with a girl child, the house is pulled down. Then it will lead to mob justice. What is mob justice basically? Justice is given by the courts after hearing the arguments, both sides of the story, and then deciding by looking at laws, by interpreting the laws, who is guilty and who is innocent. That means the judges will be fair. And then if you are declared guilty, you will be hanged or you will be sent to jail. But the mob justice is, people will not vote. People will not wait for judiciary to decide. There's a mob who are angry, irate. They will not wait for judiciary to decide who is guilty or not. They have decided that this person is guilty, even if this person is not. and will burn down his house, destroy his house, or kill him. Mob justice. But over a period of time, we have seen disturbing trends of judicial activism in India. What are these disturbing trends of judicial activism in India? We will go back to these slides, but first let me tell you what are these disturbing trends, and then you will understand the definitions that are there in the previous slides. One, a public interest litigation was filed in the Delhi High Court saying there is parking constraint in Delhi. Not enough spaces are provided for parking our vehicles. The court said, let's impose parking fee. Okay. But is that the job of the judiciary or is that the job of the executive? It is understood, it is understandable when the judiciary is saying that this law is unconstitutional, if indeed it is unconstitutional. But we cannot imagine a situation where judiciary is now taking the role of the legislature and passing its own law. We can understand judiciary saying one action of the executive is incorrect. But we cannot imagine a situation where judiciary itself is becoming an executive, taking away the role of the executive or taking over the role of the executive. Impose parking fee. Another petition, sir, there is monkey menace in national capital. Supreme Court said, we will issue guidelines. Through these guidelines, we will prevent monkey menace. Supreme Court issued guidelines that there should not be a film painted on the windows of vehicles. Film, photochromatic or whatever, where you can't see what is inside the car. Such films cannot be painted on the windows of the cars. Okay. Dear Supreme Court, we have an issue. Drinking water is the issue. Lack of water for irrigation is an issue. Supreme Court said, don't worry. What we will do, we will interlink the rivers. So all the rivers that we have in India, we will interlink them. My God, sir, even the experts are confused how to do this. How can you order it? And plus, that is not your job. Public distribution system. Fair price shops, for example, where if you are from marginalized, disadvantaged sections of the society, you are now a beneficiary, you approach a fair price shop under the PDS, public distribution system, you will get rice for 1 rupee a kg, wheat for 2 rupee a kg, pulses for 3 rupee a kg. The Supreme Court was told that there is an element of corruption in PDS. Supreme Court said, don't worry, we will monitor the functioning of PDS. Dr. Manmohan Singh was the Prime Minister, who was accused of being silent throughout his tenure. But this time he spoke. Somehow he spoke and said, dear Supreme Court, this is my job. You cannot be taking these administrative decisions and saying we will monitor the fair price shops and public distribution system. In 1990s, there is a shrine in Srinagar, Hazratbal. Militants attacked this shrine, went inside and took some of the individuals hostage. How do we deal with the situation? The government called the army. Now army is doing its own research, how to do it, how to manage, and army came up with a solution that there are militants who have taken hostages. These hostages, we give them food. This food is eaten by the militants. That is how they get the energy to fight with us for many weeks. We will stop the supply of food to the hostages. And ultimately, we will then tire them out. We will attack them. We will kill them. A public interest litigation was filed in the Supreme Court. Supreme Court said, no, 1200 calorific value of food should be given to the hostages every day. It led the then army chief to remark that Supreme Court is interfering in an ongoing military occupation. Dear Supreme Court, please stay out of it. This is not your job. This is a military operation. Come then fight with us. Fight at the borders. judicial appointments can be said as an example of judicial overreach, where collegium system is not mentioned anywhere in the constitution, where you are making some of the words mentioned in the constitution redundant. For example, if the president has to consult the governor of the state, in collegium system there is no role of the governor. This is judicial overreach. Andhra Pradesh High Court on Article 356. I've given you that example. Constitution says under Article 356, if the president is satisfied with the report of the governor or even otherwise that there is breakdown of constitutional machinery, president's rule can be imposed in that state. Andhra Pradesh High Court is accepting a public interest litigation, saying we will investigate and we will then decide whether we can recommend president's rule in Andhra Pradesh or not, because there is corruption in Andhra Pradesh. There is violation of law and order in Andhra Pradesh. How can you do that? Under what power? Under what rule? This is going beyond your call of duty, going beyond your powers, and you're entering the domain of the executive and the judiciary. Rajasthan political crisis in 2020. Sachin Pilot had some issues with Ashok Gehlot. Ashok Gehlot was the chief minister. Sachin Pilot was the deputy chief minister. Mr. Pilot had some issues. And some of the MLAs who were loyal to Sachin Pilot, they went to Haryana, they went to Delhi, they were at the hotels. They seem to have defected. Because we have discussed various Supreme Court judgments said, it's not that Sachin Pilot and those MLAs should have formally submitted resignation and then they could have been disqualified. Their conduct outside the house, if it is such that we can assume that they have violated anti-defection law, they have defected, they have voluntarily resigned from their party, the speaker could have disqualified them. Speaker did not disqualify them. Speaker sent them a notice. Why action under anti-defection law should not be taken against you? Why I cannot assume that you have voluntarily resigned from your political party? Sachin Pilot approached the Supreme Court. Supreme Court said, no, Speaker should not have given this notice. Why? Because then where is dissent in a political party? In political party, you will have members who may not agree with each other. So there will be disagreement, there will be dissent. We have to protect dissent as well. But my lord, Speaker was doing his job. It's his job under anti-defection law to decide whether somebody should be disqualified or not. He only sent a notice to Sachin Pilot and other MLAs saying and asking them reasons why action should not be taken. He did not take action. He was asking for their reasons why action should not be taken. If the speaker would have disqualified them, then you come into the picture and decide whether the speaker did it rightly or wrongly. You can't stop a constitutional functionary from doing its job. That is judicial overreach. What if tomorrow speaker tells the Supreme Court judge that you can't hear this case, stop it? Would you allow it? What if tomorrow Parliament passes a law and says judiciary cannot hear these cases? Can you allow it? You can't. And you can't be interfering in each other's domain. Enough is enough. And then in 2012, you cancelled 122 2G licenses, saying you should not have used first come, first serve basis. You should have followed the auction. Who are you? With due respect. But that is not your job. That's the job of the executive. That's not the job of the judiciary. Your job is not to make laws. Judicial legislation is antithetical to separation of powers. Your job is not to take executive decisions. And in one bizarre instance, Supreme Court is saying all the liquor shops along the highway, 500 meters of the highway, should be banned. Why? Because we have to solve the problem of drunken driving, which leads to accidents on the national highways. For that, liquor shop should be banned. What will happen to those who are working in these liquor shops? What will happen to the hotels who are along the 500 meter of the highway, who have a 4-star accreditation, who have a 5-star rating? They will lose their rating if they don't serve liquor. What will happen to the livelihood of these people? And forget about everything. What is your role? You can't take the executive decision. That's the job of the executive. That's not your job. And to solve the problem of drunken driving or accidents along the highways due to drinking problem, there are other ways of doing it. Frequent tests, regular tests, more checkpoints. You can't use a hammer to swat a fly. This is judicial overreach. So judicial review is understood. Initially, judiciary was restrained in declaring the laws or the actions of the executive and the legislature unconstitutional. Now the judiciary is eager, very quick to declare them as unconstitutional. That is judicial activism. And these are the classic examples of judicial activism. Let me recap whatever I have discussed, and these are in written format on the slides. Then we will take a break. In 1979, Supreme Court advocate Kapila Hingorani drew court's attention to a series of articles in newspaper exposing the plight of Bihar under trial prisoners, most of whom had served pre-trial detention more than the period they could have been imprisoned if convicted. Sunil Batra, he was a prisoner. He wrote a letter to Justice Krishna Iyer of Supreme Court, drawing the attention to torture by prison authorities and the miserable conditions of prisoners in jail. He wrote a postcard, a letter. This was taken up as a petition and the court passed orders for humane conditions in jail. Now you have to give them paper on which they can write their daily experiences. You have to give them books, you have to give them newspapers so that they are aware of what is happening in the society. Humane conditions in jail, despite the fact that they may be convicted. In 1982, professors of law wrote a letter to the editor of a newspaper describing the barbaric conditions of detention in Agra Protective House for women. And this letter became basis of a writ petition of the Supreme Court. Nobody approached the court. Court said this is the writ petition. The exploitation of workmen at construction sites in violation of labor laws was brought to the attention of the Supreme Court by a letter. Nobody approached. A letter was sent. Supreme Court said this is public interest litigation. The slave-like condition of bonded laborers in quarries was brought to the attention of the court by a social activist organization. So these workers did not approach the court. A non-governmental organization approached the court. The court said, we will not ask you what is your locus standi. We will accept this because you are for a larger public interest. A journalist moved the court against the eviction of pavement dwellers of Bombay. Journalists moved the court on behalf of the weaker sections of the society. Court did not ask, what is your locus standi on this matter? And that is how PILs emerged over a period of time. And Justice Bhagwati, he said, PIL is a strategic arm of the legal aid movement. We want to give legal aid to those who cannot afford the lawyers. Now we are in a situation, thanks to the Supreme Court, where if you cannot afford a lawyer, the court will give you a list and you will have to choose a lawyer if you cannot afford one. That is the legal aid movement. And one arm of this legal aid movement is PIL. And the intention of this PIL is to bring justice within the reach of the poor masses. And these poor masses are from low visibility area of humanity, as if they are not seen anywhere. People rush over them. Bollywood stars run over them when they are sleeping on the pavements, as if they are black bucks. And this is different from ordinary traditional litigation, where in original traditional litigation, two parties have to approach, then action is taken. PIL is a completely different arm, which is intended to bring justice to the weaker, marginalized sections of the society, where through these PILs, the judges appoint amicus curiae, the friend of the court, lawyers who assist the court in giving them justice. That's what Justice Bhagwati said. And the significance is, no longer were the court's clientele drawn from landlords, businessmen, corporations, and affluent persons. Previously, if this is the court, who was present in front of the court? Either the wealthy, landlords, corporates, bourgeois class, or those poor people who were brought by the state that you need to convict them. That means if at all against the state cases were to be filed, against the state we had these wealthy corporations, top landlords, top bureaucrats, or businessmen. But now the clientele before the court, we see disadvantaged, marginalized sections of the society. They are also part of these cases. They file cases against the court with the help of social activists. This unique judicial activism, which was not found in other countries, and leading judges abroad, for example, Lord Harry Wolff of United Kingdom and Justice Michael Kirby of Australia, they have applauded this, thanks to Justice Krishna Iyer and Justice P.N. Bhagwati. This is something that we have not seen anywhere else. You are opening the doors of your judiciary to marginalize poor sections of the society because they can't approach you directly. They're approaching you through non-governmental organizations, civil society organizations, and public-spirited individuals. But over the years, this social action dimension of PIL has been diluted and eclipsed by another type of public cause litigation, basically personal interest litigation or publicity interest litigation. And this publicity interest litigation is basically choking the judiciary, choking the time of the judiciary, wasting the time of the judiciary. The Supreme Court ordered control over automobile emissions, air and noise and traffic pollution, gave orders for parking charges, wearing of helmets in cities, cleanliness in housing colonies, disposal of garbage, control of traffic in Delhi, make compulsory the wearing of seat belts, ordered action plans to control and prevent the monkey menace in cities, control of loudspeakers, banning of firecrackers. All these were ordered by the Supreme Court. But the problem is, in none of these matters, fundamental rights were involved. These are petty administrative matters which come under the domain of the executive. Why should judiciary get involved in these executive matters, in these petty small matters? Not only does it waste the time of the court, it violates the separation of powers, which the Supreme Court itself has said is part of the basic structure of the Constitution. In the recent orders, the Supreme Court has directed the most complex engineering of interlinking rivers in India. The court has passed orders banning the pasting of black film on automobile windows. On its own, the court has taken notice of Baba Ramdev being forcibly evicted from Ram Leela grounds by the Delhi administration and censured the Delhi police. On its own. It's okay. But the court, all these are managerial exercises by the court. And it violates separation of powers because the court is only moved for better governance and administration. Normally, you approach the court if your rights have been violated, if you have been wronged, if your rights have been snatched. But here through PIL, you are approaching the court for better governance. For better governance, you can't approach the court. You approach the court if your rights have been violated, if you have been wronged, if you have been illegally arrested. Tomorrow, what stops these people from approaching the court saying income tax should not be 30%, it should be 20%? And can Supreme Court say it should be 20%? Because that is the only thing which is left now. If you can approach the court and ask the court that there is no cleanliness in our housing colonies, the court will order cleanliness. You have to start wearing seat belts. You have to start wearing helmets. Then what stops a court tomorrow from imposing taxes as well? From reducing taxes as well? Anything can be done by the court. That is a disturbing trend. And these disturbing trends we saw in judicial appointments cases, in Hazratbal operation, Andhra Pradesh High Court order on Article 356, the Supreme Court order on anti-defection petitions in Rajasthan, cancelling of 122 2G licenses. This is not judicial activism. This is judicial overreach. Justice Jackson, he was highly critical of this. He said this doctrine of judicial activism goes against democracy. Who are these judges? Unelected. Who are these representatives? Elected. So this is what Mr. Arun Jaitley said, tyranny of unelected over the elected. This doctrine of judicial activism, which justifies easy and constant readiness to set aside decisions of other branches of government, is wholly incompatible with the faith in democracy. Legislature, which is elected by the people, is passing a law, and judiciary is saying this law is unconstitutional. It goes against democracy. Executive, which is drawn from the legislature, who are also elected, they take certain decisions or they do not act in a certain manner. And judiciary interfering, becoming an activist and forcing executive to do something, it goes against, it is incompatible with the idea of democracy. And insofar it encourages a belief that judges should be left to correct the result of public indifference, it is a vicious teaching. Through judicial activism, you are encouraging a belief that if executive is not doing its job, judiciary should come into the picture and fill that gap. This is blatantly wrong. This is vicious thinking. This is vicious teaching. Then it goes against the spirit of the separation of powers, which is part of the basic structure of the Constitution. But over a period of time, we have witnessed another concept in judiciary called judicial evasion. Judicial activism is judiciary is ready, eager, anxious to quickly declare the law as unconstitutional, to quickly declare the actions of the executive unconstitutional, to quickly interfere, take away the role of the executive, take over the role of the legislature. But in some matters, we see judiciary is like sleeping, not taking any action at all. Delays hearing or deciding a case, thereby deciding a case in favor of the executive. What if your friend and you got into a dispute, got into a fight in a school, and then you approach the principal? Principal has to decide who is right, who is wrong, who should be punished, who should be given compensation. You know you are right. You know your friend initiated this fight, slapped you, abused you, or took away your money. So you should be compensated. That person should be suspended. Your friend, action should be taken against your friend. Who has to now take this decision? The principal. What if principal first heard you and then realized, yes, you are right and he's wrong? But now it is not, the principal is not giving you the second date when we are going to meet again. You try to approach the secretary of the principal. I need a meeting with principal, sir. Later. Sir is busy. So many things pending. Sir is busy. When you delay, you are basically siding with whom? I am siding with your friend who should have been punished. But I'm delaying action up to a point that now it becomes meaningless because you have already passed the examination. Now you're exiting the school as well because you were in the 10th standard. Now for your 11th standard, you have to go to a different school. I'm delaying the action on your matter to such an extent that once I give the judgment, it will have no value whatsoever. Once both of you have passed the 10th standard, now I will say, no, your friend is wrong. He should be punished. We are expelling him from the school. Principal, sir, you can't expel because he has already left and joined another school. So why are you expelling him now? Similarly, there are cases which are to be heard by the Supreme Court. The Supreme Court is evading, either not hearing these cases or delaying these cases to such an extent that once the verdict comes, it is of no value whatsoever. The verdict is academic in nature. Academic in nature in the sense, demonetization. Whether demonetization was right or wrong, I think it was 8th of November 2016. Mr. Modi at 8 o'clock, 16th of November 2016, 8 o'clock in the night, Mr. Modi approached the nation and said, Mitro, from now onwards, 500 and 1000 denomination notes would cease to be legal tender. That means these are worthless piece of paper. Petitions were filed challenging this demonetization exercise. On what ground? It violates right to property. Article 300 capital A. Right to property can be snatched. Your property can be snatched, but it can be only through law. This demonetization was done through a government order, through a government notification. The question also was that who can initiate this demonetization? Sorry. The question before the court was, who can initiate this demonetization? Should it come from RBI or can the government on its own decide it? The question also was, can you demonetize all the currency notes or only the series of currency notes? Because on every note you will see a number, that's the series. So can you demonetize only those series of notes or all the notes belonging to 500 or 1000? Demonetization happened in 2016. The judgment came this year. That means the courts delayed the decisions on this matter to a point where, number one, the final judgment is only of academic in nature. You should not have done this, you should have done this, you could not have done this, so on and so forth. Basically, you're siding in favor of the executive. Electoral bonds started in 2017, and we will discuss tomorrow what are these electoral bonds. Basically, through electoral bonds, you and me will never come to know who is donating money to a political party, which basically means it lacks transparency. Whatever lacks transparency encourages corruption and violates my right to know whom to vote for this election, because I need the right to know, I need information to decide who is the better candidate for me. 2017 and we are in 2023. Now the court is hearing this matter. And by that time, how many state elections has the BJP won? How many national elections has the BJP won? Because this money is very important for a political party to win the election. You delay the decision to such a point that after that it becomes irrelevant and you are basically siding with the government. Similarly, Citizenship Amendment Act passed in 2019, we still don't have a verdict. Article 370 petitions happened in 2019, we still don't have a verdict. At that time, the Supreme Court was asked, said it looks that it is blatantly unconstitutional. Please at least impose a stay on Jammu and Kashmir Reorganization Act. Why? Sir, you may take a lot of time to decide whether this action is right or wrong. But by that time, if the state is already divided, converted into 2 union territories, then what could you possibly do? The state is divided, 2 union territories are created. Court said, don't worry. We won't take that much time. And even if we take time, we will set the clock back. Neither the clock is set back, nor did they honor their word that they will not take so much time. Jammu and Kashmir internet ban. When Article 370 was to be diluted, special status was to be taken away, rightly, internet was suspended, landline phones were stopped, mobile phones were stopped. Yes, because you anticipate violence. And you can't take action after the violence has erupted. You have to prevent violence from taking place. And for that, it was justified to impose certain restrictions. But for how long? This ban continued, but internet is a necessity as well. Through internet, you study for your exams. Through internet, you run your website, e-commerce website through which you get your livelihood. So your right to education as a fundamental right, your right to livelihood as a fundamental right, your right to carry out any trade, occupation, business is your fundamental right under Article 19(1)(g). All these fundamental rights get violated if you indefinitely block internet. Matter went to the Supreme Court. Supreme Court said right to access internet is a fundamental right. Beautiful. Everybody was happy. Wow, what a verdict. But whether internet ban should continue or not, for that we will set up a committee, and this committee will decide whether internet should be banned, should continue to be banned, or should this ban be lifted. Who is part of this committee? Secretary of Ministry of Home Affairs, Secretary of the Central Government, Chief Secretary of Jammu and Kashmir. These three people will come and tell us whether internet ban should be lifted and when it should be lifted and whether it should be continued, till when it should be continued. What is the problem with this? Supreme Court is asking the same people you tell us whether internet ban should continue or not, the same people who imposed this ban. So Secretary of Home Affairs, Ministry of Home Affairs, Secretary of Telecommunication at the central level, the Chief Secretary of the state, they are responsible for implementing this ban. And the Supreme Court is asking them, please tell us whether this ban should continue or not. This is judicial evasion, where the judiciary is evading questions of important nature, basically deciding the case in favor of the executive. That is judicial evasion. We'll meet after the break, and then we will look at the conclusion, why there are cases, so many cases which are pending. Then we will look at high courts, we will look at the tribunals, we will look at the Lok Adalats, and by 10 o'clock we should be done with judiciary. Then we will meet tomorrow at 6 o'clock in the morning, and we will start with elections. We will meet at 8:25. See you on the other side. Now let's continue and look at why is justice delayed. According to 2021 report, there are more than 73,000 cases which are pending in the Supreme Court. But if we add all the cases which are pending in the district courts and high courts in all the states, this figure touches 44 million. That means close to 4.5 crore cases are pending in different courts in India. Why is there such a huge backlog of cases in the Indian judicial system? There are three areas of concern. Areas of concern is not just that number of cases are pending, it's also because the way the judiciary functions. Our judges are concerned about the environment. When they're concerned about the environment, but when we look at them, they need to understand why these cases are pending, because they have a lot of time to understand it, because they take lots of holidays. Supreme Court is currently working for 193 working days in a year. High courts are working for 210 days. And the trial courts, the subordinate, the district courts, they function for 245 days. The Supreme Court has 5 vacations in the annual calendar. A summer break of 45 days, a winter break of 15 days, holy vacation of a week. It closes 5 days each for Dasera and Diwali. There are 73,000 cases which are pending before the court. This is, if we look at all the other courts in India, it touches 44 million. And the number of cases which have increased, the percentage increase from last year is 19%. So it keeps on adding. So if old cases are not disposed of, new cases keep on adding, which means you're piling up the pending cases. One reason is that the number of holidays, the number of holidays or vacations taken by the courts are huge. On top of that, our judicial system remains the least digitized area of governance. Less and less digitization. 2019 investigation was done by the Quint.com. Supreme Court, according to this column, who are very concerned about pollution and deforestation, Supreme Court uses 48 million sheets of A4 sized paper every year. And on this paper, you have to mark two extremes. Each word will be of 13 to 14 font size, double spaced from two sides, with 3 centimeter margin on either side of the page, which means you are destroying millions of trees for the manufacture of paper, and at the same time you're concerned about the environment, but you're not digitizing your judgments, you're not using digitization methods, you are consuming a lot of paper. That is another problem. Problem is further compounded by 3 big areas. Why are there so many cases pending in the court? Because there are so many loopholes in the law, particularly when it comes to our property rights, particularly when it comes to the tenancy rights. For example, I am a tenant. This is not my flat. The owner is someone else. I am taking this flat for rent. I am now a tenant. Now, this owner cannot evict me without giving me an alternate accommodation. Since the law is unclear, law has lot of loopholes, and if we have to exploit these loopholes, I go to the court. That means problem number 1 is that there are lots of loopholes in the law, and to exploit that loopholes, we have to go to the judiciary. Judiciary, the cases keep on piling, and ultimately justice delayed is justice denied. So the problem is not only with the judges, the problem is with the laws which are poorly drafted. There are lots of lacunas and loopholes. We need to fix these loopholes and lacunas, make the law foolproof, error-proof, and that is how we will not see cases moving to the court. Second, our legal proceedings themselves are complicated. And that has been immortalized by Sunny Deol, wherein he says, Tariq pe Tariq pe Tariq. You get a date of hearing in a court, but you don't get justice. Because there are frequent adjournments also. In a case of 50 hearings on an average, there will be 10 to 15 adjournments, that too on inconsequential grounds. For example, I'm a lawyer. This is my case, but I also have case in another court, or I have different cases. What I do, I ask the judge for an adjournment. I am not available today. Can you please give me a new date? I am unable to cross-examine the witness on this ground. Please give me a different date. Multiple reasons are cited, and ultimately the case is delayed. There are frequent adjournments, and you get a date of hearing in a court, but you don't get justice. On top of that, there is acute shortage of judges in India. At present, we have 10.5 judges per million population. Whereas this number should have been, we should have 50 judges per 1 million population. This idea is then, when there are less number of judges, more number of cases, that means that some cases will be prioritized, some cases will be kept at the back burner, the cases keep on piling, and this is the reason why justice is delayed in India. Look at the vacancies. In all the 25 high courts that we have, the vacancies are more than 25%. Not only do we have less number of judges per million population, even the number of judges that should have been, there are vacancies, and we have been unable to fill these vacancies. That is another problem. Economic Survey gave its report, and its report, it says, this is last year's Economic Survey, it talked about 3.5 crore cases pending in the judicial system. Majority of these cases are in district and subordinate courts, where 87.5% cases are pending. What are we discussing? Why is justice delayed in India? Why are there crores and crores of cases pending? Majority of the cases pending at the district and sessions court, at the subordinate courts, then at the high courts, then close to 73,000 cases at the Supreme Court. What is the reason? The reason is, number one, we have less number of judges per million population. Even if we should have 10 judges, but there are 3 vacancies, we are not able to fill those vacancies. That is another problem. Another problem is the laws are poorly drafted. There are lacunas and loopholes in the law. And then to resolve these lacunas, you go to the court, the case keeps on pending. Even when the court is giving you a date, in a case which involves 50 hearings, you will have 10 to 15 adjournments, that too on inconsequential grounds. That is also the reason for delay. On top of that, we are the least digitized judiciary in the world, where if, for example, the case is decided by the High Court, then it is typed on a typewriter, the judgment is typed on the typewriter, and then it is given to the petitioner. Petitioner has to collect this copy and then approach the Supreme Court. If it needs a court document, it has to be couriered to the court. All this is typed, and it is also not environmentally friendly as well, because you use A4 size sheets with 3 centimeter margin on both sides, 13 to 14 font size, which means you are consuming millions of papers, which affects our environment as well. Then what is the solution? Global best practices is something that we have to follow. That means we have to look at what other countries are doing, why in these countries justice is not delayed, why in these countries the crores and crores of cases are not pending. We have to incorporate those best practices in India. For example, in Scandinavian countries, for example, Sweden, Iceland, Norway, although the population of these countries is small, but even then these practices can be utilized here. And what are these practices? First, you have to go through ADR. What is ADR? Alternate dispute resolution. You and me have a dispute. What is the word or language that you will use for me? I will see you in court. Two groups have a dispute. They're not able to resolve their dispute. They tell each other, we will see you in court. Why? Because we don't see any other alternative. The only place where we assume or feel that our disputes can be resolved is the court of law, is the judiciary. we need to explore other alternatives. And what are these other alternatives? For example, arbitration. What is arbitration? There is party A, party B, they have a dispute. Let's say A's company merged with company B, and now company B is violating the terms of merger. There is a dispute. Where should this dispute go? To the court of law. But there are already cases pending. When there are already cases pending, that means it will take a lot of time for this case to be resolved. That means justice denied is justice delayed is justice denied. Instead, we should take the arbitration route. What is arbitration? Both of them will approach a third party. C. C is neither connected to A, C is neither connected to B. But both A and B agree that we will go to C, whatever C says will be binding on both of us. That means C will arbitrate in this dispute between the two parties. If we will include this in all cases, we will see less and less number of cases approaching the court. One such alternate dispute resolution is Lok Adalat. Lok Adalats which take up civil cases. They won't take up criminal cases, they will take up civil cases. Except check bounce case. I gave you a check of 10 lakh rupees. You went to encash that check. There is no money in my bank account. The check has bounced. This is a criminal case. And this is the only criminal case which can be handled by Lok Adalat. Lok Adalat, they have legal recognition because of Legal Services or Legal Authorities Services Act 1986. Lok Adalat will have a retired judge or a sitting judge. It will have an advocate. It will have a social activist. Look how convenient this arbitration is. What is convenience? If I approach the court, you also approach the court, you have to pay fee to the court. That's number one. Second, you have to hire a lawyer. You have to pay fee to the lawyer as well. Instead of going to the court, if you go to a Lok Adalat for your civil cases or check bounce case, you don't need to pay any fee. You don't need to hire any lawyer. You will present your side of the story. The other party will present its side of the story. And now these three people will decide, will give the final verdict. Who should get compensation and who should not? For example, cases involving divorce, cases involving medical insurance, cases involving motor insurance. Lakhs and lakhs of such cases are filed in various courts every single day. Instead of going to the court, why don't you go to the Lok Adalat? And whatever decision is taken by the Lok Adalat will be binding on both the parties. It will be effective as well. It will be cost saving as well. It will be quick as well. And ultimately, justice will be quick, swift. That is what we need to encourage. Fortunately, these Lok Adalats are working well in the southern India, but unfortunately, they're not working well in Uttar Pradesh, in Uttarakhand, Rajasthan, Madhya Pradesh, Chhattisgarh, Bihar areas, which means we need to create more awareness in the society, ensure that instead of going to the court, the first option should be a Lok Adalat. The first option should be arbitration. And whatever decision is taken in this arbitration, that is binding on both the parties. That is what we need to do and follow in all cases in India. At least in all the civil cases, if not in criminal cases. That we should file and approach an arbiter. We should resort to arbitration instead of regular courts, because it will be time saving, it will be convenient as well, it will be swift as well, it will be cost saving as well. That's what we need to do. That's solution number one. Solution number two, in Australia, there is provision for electronic filing of cases. Unlike in India, where there is huge amount of paperwork involved. Delay is also because I have to get the court documents, the verdict, the judgments, and then through this paperwork, I have to approach the higher court. It takes time. Instead, can I not file this case electronically? Digitization, less amount of paperwork. If I have to call the witness, instead of asking this witness to be present in the court, why can't I also ensure that through remotely Zoom or any other platform, Zoom like platform can be developed so that electronically we can cross-examine the witnesses. Use digital technology to increase the number of cases that you can hear on a daily basis. Reduce the pendency on the paperwork. Problem solved. Certain countries have adopted discovery system where each litigating party must disclose its evidences to the other party so that both the parties are able to examine the evidences. I have a case against you. Let's say the case involves you were wrongly terminated from your service. Now you are questioning me, why am I wrongly terminated from my service, from my job? I will go to the court. Instead, the first step should be, you have your lawyer, I will have my own lawyer as well, and we will share evidence with each other. So you were not wrongly terminated, but you were terminated because your performance appraisal was bad. You were terminated because you indulged in corruption. You withdrew some amount of money from our company's bank account. You spent it on your own. So you have indulged in corruption. That is why we have terminated you from the service. Or we terminated you from the service because of sexual harassment that you perpetrated against a female employee. So when all this evidence is presented before each other, your lawyer will advise you, please settle. Don't let this case go to the court, because ultimately the court will punish you. You will lose it. And it will take a lot of time for the court to give the verdict as well. Let's settle with each other. That should also be encouraged. So this discovery system, electronic filing of cases, we saw what COVID did to India's judicial system. Despite the fact that the world was under lockdown, judiciary was functioning. But we resorted to remote-based judicial proceedings, where the judges are sitting in their homes or the judges are sitting in the court, but the petitioners are not there in the court. They are attending virtually. If you see the current Supreme Court proceedings, there are some advocates who approach the court but via a remote link. They're not physically present in the court. They are joining via a technological device remotely. It will encourage more and more swiftness in our judicial proceedings, and ultimately the number of pending cases will reduce. Not just this, what we need to take into account suggestions of various committees which have been constituted for this purpose. And if we club all the recommendations of these committees, we can say that we need to constitute more number of benches. More number of benches in the sense, currently, if in the Supreme Court we have a Chief Justice and 33 other judges, instead of sitting three judges on a particular case, obviously the constitutional case involves 5 or more judges, but all other cases we can set up one judge. One judge will hear a case, other judge will hear another case. Set more benches, more number of cases, more number of deciding appeals, and ultimately the number of pending cases will reduce. Increase the number of judges. If you look at our population, we have 10.5 judges per million population. Increase it, recruit more judges. So we should have 50 judges per million population. Computerize the entire judicial process, which will make your appeal quicker, which will enable you to file an appeal against your judgment quicker, because the moment judgment is given, instead of typing this judgment, it is uploaded on the server. and bunching of similar cases together. For example, we have motor vehicle insurance cases at the district court. And there is one insurance provider, let's say Life Insurance Corporation of India, or let's say it is ICICI Lombard. All the cases against ICICI Lombard involving motor vehicles insurance claims, let's club them together and let's decide once and for all. Instead of hearing one case which may be similar to another case, because all these cases are similar. All these similar cases, bunch them together, give one judgment, problem solved. Because what justice delayed means in India, we saw in 2019, there was a girl in Hyderabad. She was a medical student or a physiotherapy student. She was raped, allegedly raped, and then killed as well. And initially, 4 people were arrested. 4 men were arrested. When these 4 people were arrested, they were taken to the scene of crime, because the accused are taken to the scene of crime, where they have to show if there is any evidence, where did you commit this crime, blah, blah, blah. And ultimately, the police said, alleged, that these 4 people, they were running away. They tried to run and we killed them. That means when they tried to run, we killed them. There was widespread support for the police for this matter. But it was a fake encounter. Fake encounter in the sense, if they were running, why didn't you run after them and catch hold of them? Or if they were running, why didn't you shoot at their legs so that they could not run and you can catch hold of them? Why did you shoot to kill? That is not your job to decide whether they are guilty or not. That's the job of the judiciary. So police taking law into its own hands and killing people in fake encounters. We saw a gangster from Uttar Pradesh. He was arrested in Madhya Pradesh and then he was brought to UP. And in a Bollywood style, this car in which he was traveling, this police vehicle, it turned turtle. And then the police said, Mr. Vikas Dubey tried to run. The gangster tried to run and then we had to shoot him and he is dead. It was a fake encounter. But people support it. Why? Because people support it because they think, and rightly so, that if this rape case would have gone to the court, just like Nirbhaya case went to the court will take its own sweet time to decide whether you are guilty or not. So the case will linger on for 4 years, 5 years, 6 years, 7 years. We don't have faith in the judicial system. It is better if the police would kill these rapists. But what if those 4 people were not rapists and killers? What if they were innocent? Which basically means you're killing these innocents without giving them the opportunity to prove their innocence. And the real problem, the bigger problem is the real rapists, they are roaming free. And they might be preying on a different catch. That means this delay of cases in our system has morphed into a social problem. If this delay continues, then people's faith in judicial system will be eroded. Then people will start taking law in their own hands and will start killing the accused. This would be mob justice. The widespread support for the encounter killing of the 4 accused in 2019 Hyderabad gang rape and murder is a symptom, albeit an extreme one, of the increasing trust deficit between the citizens and the justice system. The prospect, the very thought that delayed justice is one of the driving factors of this trust deficit, it's prompting people to support extrajudicial actions, such as fake encounters. This shows that the problem of judicial delay has morphed into a social issue with potentially terrifying ramifications for India's constitutional and democratic structure. It is going to affect our democracy, where there will be no rule of law, because people will start taking law into their own hands. So we need to urgently address this problem of delayed justice, where there are crores and crores of cases pending. For that, what we need to know, we first need to know why are these cases pending. Once we have that idea, why are these cases pending, then we can propose solutions. Why are these cases pending? least digitization, more paperwork, less number of judges, frequency in adjournments, lack of alternate dispute resolutions, or the popularity of these alternate dispute resolution mechanisms. The solution is bunch the similar cases together, increase the number of judges, increase the number of benches, more and more computerization, more and more remote taking of cases where you don't need to be physically present as well. And you need to amend your laws, make them foolproof, remove all the loopholes that are there to be exploited. Because of these loopholes, cases go to the court. There are 44 million cases clogging India's district courts. Nearly 21% of these cases have been pending for 5 years or more. The issue of judicial backlog and delay is widely acknowledged and extensively written, but it seems to be nowhere close to being resolved. Indian Times of India did a report and said if all the judges would sit 24 hours a day without taking any break, it will take 3 years to resolve all the pending cases. And in these 3 years, every year 19% increase we see in the cases. That means in these 3 years, we will come up with more number of cases. That means today, if all the judges in this country, all the judges at the district court, high court and Supreme Court will not do anything else but just hear these pending cases, it will take them 3 years to resolve these cases. But in those 3 years, when they are not taking any other case, the number of cases will still continue to pile up. Today, a litigant, somebody who's approaching the court, can be stuck in the court corridors for 20 years if a case goes all the way to the Supreme Court. The original litigant may not be alive by the time the apex court resolves this issue. What if you get justice in a case after 20 years? Would you call them justice? Would you call it justice? So it is a stretch to describe any verdict given after 20 years as justice. That is why we need urgent steps to resolve the pending cases. And for that, the steps that we prescribed are more than enough. Then let's come to the high courts. Constitution says there shall be a high court for every state. But one high court for one state, that is not something which is mentioned in the Constitution. So we can have one court which is common for more than one state or union territories. How many high courts do we have? 25. That means for 28 states and 8 union territories, we have 25 high courts, which means there are some high courts which are common. Punjab and Haryana High Court is common for Punjab, Haryana and Chandigarh. Guwahati High Court is common for Assam, for Arunachal and Mizoram. Which means these high courts will have a chief justice and as many judges as may be appointed by President. Listen to me carefully. We have the Supreme Court, which is consisting of Chief Justice of India and 33 other judges. Who can increase the number of judges? Parliament. We have 25 high courts. Every high court will have a Chief Justice and as many judges as may be appointed by the President. That means to increase the number of judges, to prescribe the number of judges for a high court, that is not done by the Parliament, that is done by the President. After consultation with the government and the Chief Justice, 100%. What is the qualification in order to be appointed as the judge of a high court? That we have discussed. You should be the citizen of India and you must have held a judicial office for 10 years. Citizen of India, should have been an advocate in one or more high courts for 10 years. If you're qualified, you can be appointed. And what is the process of appointment? Same as that of the Supreme Court judge, collegium system. Once you're appointed, you continue for a specific age. That means till the age of 62, you are the judge of a high court. But even before you complete 62 years of age, you can be removed. And that process of removal is mentioned under Judges Enquiry Act of 1968. So same process of appointment as that of a Supreme Court judge, same process of removal as that of a Supreme Court judge. That is there for a high court. After that, you don't have to study high court separately because that is not relevant for your exam. But what we need to understand high court is from the mains perspective. And in mains examination, you may be asked that jurisdiction of our high courts has been subject to relentless attack. Who is the attacker? One attacker is the Supreme Court. The other attacker is the Parliament. Our high courts are constitutional courts. That means our high courts are created by the Constitution, just like Supreme Court is created. Our high courts can take up all cases. Whether it is a fundamental rights violation cases, whether it is a challenge to a constitutional amendment act, whether it is a challenge to any central law, any case can be heard by the High Court. Can a constitutional amendment act be challenged in the High Court? Yes. Can a central law be challenged in the High Court? Yes. In fact, the reason why first Constitutional Amendment Act was passed in 1951, it was triggered by a judgment of Patna High Court. Patna High Court declared Zamindari abolition as unconstitutional. Patna High Court declared that Land Reforms Act is unconstitutional. It was basis of the judgment of the Patna High Court that first Constitutional Amendment Act was passed. Article 31A, 31B, 9th schedule was added to the Constitution. So our high courts were given enough prominence by the Constitution. Same protection as that of a Supreme Court judge was given to a High Court judge as well. And the purpose of high courts was, when the cases will reach the Supreme Court will benefit from the wisdom of high courts. And some of these high court judges will go to the Supreme Court, which primarily means that high courts, which hear all kinds of cases, and you have the judge of a high court, and as the judge of the high court, you hear all kinds of cases, whether it is tax related, constitutional amendment, central law, bail, murder, dacoity, any case, which means you are trained at the high court and then you move to the Supreme Court. Then you can move to the Supreme Court, you can be promoted to the Supreme Court. That means high court is like your stepping stone to move to the Supreme Court. So when you get a case in the Supreme Court, you will not be stumped, because you have handled all these cases in the High Court as well. And plus, whatever judgment is given by the High Court, that goes to the Supreme Court, that can go to the Supreme Court. Supreme Court will benefit greatly from the wisdom of these judgments. That means a particular case, listen to me carefully, a particular case, let's say the case of murder. District Court gives a verdict. Then this case is reviewed by the High Court. High Court will also give the verdict. Then this case can go to the Supreme Court. But who gave the first verdict? District Court. Whether that judgment was correct or not, first level of review was done by the High Court. So if now another review is to be done by the Supreme Court will benefit from the review given by the High Court. What if there is no High Court? What if the case directly goes to the Supreme Court? Supreme Court will not have the benefit of a High Court judgment. That means Supreme Court will have to take its own time to come and arrive at a conclusion, whether you are guilty of murder or not. That was the position given to the High Court. High Court judge appointed by President, removed by President based on the resolution passed by the Parliament. Same protection that is given to Supreme Court judge was given to a High Court judge as well. High courts can hear all kinds of cases, including fundamental rights, constitutional amendments, central laws. But over a period of time, we have seen High Courts have lost their prominence. And they have come under attack. One by the Supreme Court itself, the other by Parliament. Supreme Court how? Hyderabad, a case of rape and murder. The Hyderabad High Court, the Telangana High Court took so moto cognizance of this case. The High Court judges heard this matter, read this in the news, and converted that into a public interest litigation, and now is hearing this matter. Supreme Court said, oh, this is a publicity case. All the eyes of the people are now on the Telangana High Court. So what we will do, Supreme Court said, transfer this case to us, we will hear this matter. Which means Supreme Court is now imposing its writ on the High Courts and transferring High Court cases to itself. Now you might say, what is the problem? Look at the problem. If we have a state and we have an individual, if an individual loses a case at the district court, he has the option of convincing a High Court. Loses it there as well, he has the option of convincing the Supreme Court. Loses there as well, he has lost the case. What if the petitioner is the state? State lost a case in the district court, files an appeal before the High Court. Lost a case there as well, files an appeal before the Supreme Court. Lost a case in the Supreme Court as well, it has Article 143, presidential reference. It can refer the same case again to the Supreme Court, asking the opinion of the Supreme Court on that matter. That Article 143 is not available to me as an individual. So if High Court is gone, the case is directly at the Supreme Court. What if Supreme Court makes a mistake? You can't rectify that mistake now. Yes, you can file a review petition and then a curative petition, but then what is the success rate of those petitions? Same judges who dismissed your case will hear your review petition. That is why there has to be this High Court in the middle who can give judgment which can benefit the wisdom of the Supreme Court. And if you isolate High Court and take the cases directly from the High Court to itself, and now if the judgment is given by the High Court, where will a citizen go? Citizen, unlike the state, does not have Article 143 for its protection. So one attacker of the jurisdiction of the High Court is the Supreme Court itself, and the other is the Parliament. And if High Courts lose their prominence, India's justice delivery system will be the principal loser. And how Parliament is attacking the jurisdiction of the High Courts? Through tribunals. What is a tribunal? 42nd Constitutional Amendment Act was passed. The year was 1976. Article 323A, Article 323B was inserted into the Constitution. Article 323 allowed the central government to set up tribunals for administrative matters. Article 323 allowed Parliament as well as state legislature to set up tribunals on other matters. Other matters such as election, other matters such as urban land sealing, any other matter, tax matter, other tribunals can be set up. So 42nd Constitutional Amendment Act 1976. gave constitutional status to tribunals. That means under Article 323, capital A, the central government may set up a tribunal for administrative purposes. What is that administrative purpose? For example, CAT, Central Administrative Tribunal. And Article 3, who can set up a CAT? Only the central government, not the state government. So even the state administrative tribunal is set up by the center. But Article 323, capital B, talks about tribunals for other matters. Other matter can be election disputes, urban land ceiling, any other matter. What is the purpose of this tribunal? And what are these tribunals basically? These tribunals are quasi-judicial bodies What's a quasi-judicial body? That means it will have members from judiciary. It will have some experts as well. And then they will take a decision. And there were two reasons why these tribunals were set up. Two good, genuine reasons. One, to save the time of the ordinary courts. Second, to use the experience of experts. We have district court, we have high court, we have the Supreme Court. Clear? Any case will have to go to this judicial institution. Fine. But instead, what the government decided, we will have a tribunal, which is a quasi-judicial body, which will have members from judiciary, which will have experts as well. Why? Because we will save the time of the ordinary courts. There are crores and crores of cases pending. There's an urgent backlog of all these cases. How do we resolve this backlog? We will give some of these matters to other bodies, tribunals. For example, I am giving you a task. Prepare 100 MCQs. Tomorrow we have a test for the students. You are overburdened. You can't make 100 MCQs. I give 40 MCQs to another candidate, 20 MCQs to another candidate, and tell you, you make 40 MCQs. There are 1,000 cases pending. I will transfer some of these cases from judiciary to these tribunals. That means the load on the ordinary judiciary will be lessened, and at the same time, justice will be quick. And at the same time, we will use the services of experts. Who are these experts? For example, there is a dispute on taxation. I have paid taxes. The government says you should have paid more tax. Matter will go to a court because there is a dispute between me and the state. Instead of going to the court, why don't we go to a tribunal where there will be judges as well, there will be experts as well. Judges who will interpret the constitution, who will interpret the laws, and experts who are from taxation field, who understand each and every nitty-gritty about these taxes, who will understand whether I have laundered the money or not, whether I have deliberately avoided paying taxes, whether I have made some tweaks in my Form 16, which is given by the employer when you are paying the taxes, whether I have done something misconduct in my Form 16. They know because they are the experts. So these tribunals will give quick judgment, better judgment, because it is benefited by the wisdom of judges as well as the experts. And that is how these tribunals were set up. But over a period of time, one by one, more tribunals were set up. More tribunals were set up, and any decision of tribunal was to be reviewed by Supreme Court, not a High Court. So when more and more tribunals were set up, this is what we call blatant tribunalization. More and more tribunals were set up. That means, number one, what happened? From the regular judiciary, we took away some matters and gave these matters to tribunals. Now, income tax matters go to the tribunal. Environmental related matters go to National Green Tribunal. Stock market related matters go to SEBI. Another matter go to another tribunal. You have a problem with the film certification, go to a tribunal. You are a director, you are a producer, you made the movie, but this movie was not given permission by the censor board or Central Board for Film Certification, CBFC, you go to a tribunal. That means when you create tribunal after tribunal after tribunal, that means you are snatching the powers from the high courts, from the regular courts, and then you are dumping high courts, because you are saying if you are not satisfied with the judgment of the tribunal, you don't have to go to a high court, you go to the Supreme Court. Which means if I am a high court judge, environmental related cases, taxation related cases, stock market related cases, film related cases, they never come to me because I am a high court judge. But tomorrow when I am promoted as the Supreme Court judge, now these cases come to me. I have never handled these cases before because these cases did not reach me when I was in the high court. Now these cases are reaching me when I'm in the Supreme Court, but I have no experience. How will I perform? This is how high courts were come under. High courts have been relentlessly attacked. One, by the Supreme Court, when Supreme Court is taking these cases to itself. And second, by the Parliament, by setting up tribunals after tribunals after tribunals and saying, if you're not satisfied with the verdict of the tribunal, you go to the Supreme Court. Plus, these tribunals violate independence of judiciary, which is part of the basic structure of the Constitution. Why? Because these tribunals have judges, have experts. Who is appointing these experts? Central government, the government of the day. And this tribunal has to give verdict against whom? The government. So government is appointing you, and we expect you to give a verdict against the government. Will you? You will not. That means independence of judiciary is violated. And over a period of time, various judgments have been given by the courts. One was L. Chandra Kumar. And Supreme Court said, these tribunals, they have the potential of violating independence of judiciary. They are violating the sanctity of the high courts. So any judgment of the tribunal can be reviewed by high court. That means this practice, where if you're not satisfied with the verdict of the tribunal, you go to the Supreme Court directly, bypassing the high court. Don't do that. You have to approach the high court. From high court, you go to the Supreme Court. Which basically means we are still wasting the time of the court. If in any case you have to go to the high court, then you have to go to the Supreme Court, then what is the purpose in having a tribunal? If all that you wanted a tribunal for was you can also bring in experts to decide on these matters, there is nothing which can stop the Supreme Court from taking help from an expert. There is nothing which can stop a high court from taking the help from an expert. If a high court is hearing an environmental matter, the high court can always seek an expert from the environmental activist, an expert. Please assist us in this case. Amicus curiae, friend of the court. So just because you need an expert to rule on some matters, for that you create a tribunal, it makes no sense because the courts can also hire experts. If you wanted less burden on the judiciary, that's why you set up the tribunal. Now, because of the Supreme Court order in L. Chandra Kumar case, any decision of the tribunal will have to go to the High Court. So if any case will go to the High Court, then what is the need for a tribunal? And there is a bigger problem. These tribunals are set up under the ministry against whom it has to give its verdict. Exception: Income Tax Appellate Tribunal. Normally, all the tribunals that are set up, they are under the control of a ministry under which it is set up. Except Income Tax Appellate Tribunal, which is not under the Ministry of Finance, which is under the Ministry of Law and Justice. Which is under the Ministry of Law and Justice. Otherwise, all other tribunals are under the same ministry, which means if we have FCAT, Film Certification Appellate Tribunal. Karan Johar made a movie. This movie should now be given a certificate. There is no such thing as censor board, although we call it a censor board, but it is Central Board for Film Certification. Its power is just to certify films. Certify films that this film contains nothing objectionable. We will give it a U certificate. That means universal. That means anybody can watch this movie. Whether infant, adult, boy, girl, anybody can watch this movie. But if it is given A rating, that means only adults above the age of 18 can watch this movie, because movies will have influence on the minds of the young. If there is more violence, if there is more sexual content, you don't want your kid to be exposed to this content, A certificate will be given. That means only adults above the age of 18 can watch this movie. That's the job of the Central Board of Film Certification. I have made a movie. It contains some horror scenes which you don't want your children to be exposed to. I approach the CBFC for the certificate. It gives me A certificate, but I don't want A certificate. I want U certificate. Why? Because if it is given A certificate, I will lose revenue. Why? Because then parents cannot come along with their kids to watch this movie. Normally, you go to a movie to enjoy as a family. So husband, wife, their kids, they go and watch and enjoy a movie. Now, if there are two movies, one is with U rating, the other is with A rating, we have to watch a movie because we have planned for it. I can't take my kids to the movie which is with A certificate because I will not be allowed entry along with my kids. So I will go to a movie with U certificate. And now I have a dispute with CBFC. I am telling them, no, I need U certificate. They are giving me A certificate. There's a dispute. Where do I go? Film Certification Appellate Tribunal, which is under Ministry of Information and Broadcasting. CBFC is also under Ministry of Information and Broadcasting. So basically, I'm telling this tribunal, give me a verdict which favors me and give this verdict which goes against the ministry which has created you. Won't happen. That is another problem with these tribunals. With the exception of Income Tax Appellate Tribunal, which is not under the Ministry of Finance, but is under the Ministry of Law and Justice. Even then, it is Council of Ministry, reporting to the Prime Minister. Now, how do we resolve this problem of tribunals? For that, something good was done by the Parliament itself. Tribunals Reform Act of 2021. Something good was done by the Parliament in this case, 2021. But this act is good, it is bad, and it is ugly as well. What is so good about this tribunal? Number one, 10 tribunals were scrapped and their role given to high courts. So this blatant tribunalization, tribunals after tribunals were created. Now, thanks to this Tribunals Reforms Act passed in 2021, 10 tribunals have been abolished. And instead, this role has been given to the High Court. For example, Film Certification Appellate Tribunal. This has now been abolished. That means instead of going to FCAT once you have a dispute with CBFC, you can go to a High Court. Filmmakers protested. Filmmakers such as Anurag Kashyap, Hansal Mehta, others, they protested. They said this should not have been scrapped. This decision was taken hasty. In fact, we were not consulted. But this is a misplaced objection. Why misplaced objection? Because number one, Film Certificate Appellate Tribunal was in Delhi. Movies are made in Mumbai, for example. If you don't agree with the decision of CBFC, you have to go to Delhi to get a favorable order for you. Now, instead of going to Delhi, you can go to the Bombay High Court, which is very convenient for you. So why are you worried? Plus, in any case, according to L. Chandra judgment, if you're not satisfied with the decision given by FCAT, you have to go to the High Court and then to the Supreme Court. So in any case, you had to go to the High Court. So go to the High Court directly. So that is good thing about this Tribunals Reforms Act. These 10 tribunals have been abolished. You don't have to remember the names of these tribunals. Just one example, FCAT is over. So one good thing about this law is that this blatant tribunalization will stop. High courts have been restored their prominence. But what is bad and what is ugly about this law? Let's discuss. Previously, there was an ordinance passed in the year 2021. This ordinance was struck down by court. In which case, Madras Bar Association. Same provisions which were there in this ordinance, which was struck down by the Supreme Court in Madras Bar Association case, same provisions appear in Tribunals Reforms Act 2021. What are these provisions? We will discuss, but that is big problem. Same provisions struck down by the court in Madras Bar Association, same provisions appear in the Tribunals Reforms Act. In Roger Matthew case, as well as in L. Chandrakumar, the Supreme Court had flagged this concern that there are tribunals where judges and experts are appointed by the central government, but then they are under the parent ministry. They are under the control of the same ministry against whom they have to give the judgment. This violates principles of natural justice. That is why we should have a national tribunals commission. That means instead of tribunals under the individual ministries, we should have all these tribunals come under the supervision of National Tribunals Commission. So that Income Tax Appellate Tribunal will not be under Ministry of Law and Justice, will come under the supervision of National Tribunals Commission. So that Film Certificate Appellate Tribunal will not come under Ministry of Information and Broadcasting, will come under National Tribunals Commission. One National Tribunals Commission will oversee the functioning of all these tribunals so that the executive will not interfere with the functioning of these tribunals. This Tribunals Reforms Act of 2021 does not create this National Tribunals Commission. So what Supreme Court asked the government to do, to set up a National Tribunals Commission so that it can oversee the functioning of all the tribunals, that this law did not do. That is the bad thing about this law. So there is something good, that some tribunals, 10 of them, 11 of them have been abolished. Now their jurisdiction has been given to the High Court. Very good, beautiful. Thank you, Mr. Modi. But what is bad about this law is that National Tribunals Commission, which was mandated by the Supreme Court in L. Chandra Kumar, in Roger Matthew, in Madras Bar Association, in multiple cases, that National Tribunals Commission has not been set up. And what is also bad is that those provisions which were there in the ordinance, same provisions appear in the law. But the problem is these provisions were struck down by the Supreme Court as unconstitutional. But there is something ugly as well. What is the ugly part? Search cum selection committee. Your question, sir, how are these members appointed to tribunals? There is a search and selection committee for that, which consists of Chief Justice of India or a Supreme Court judge nominated by him, 2 secretaries appointed by the central government, outgoing chairperson, if a chairperson is to be appointed, current chairperson, if a member is to be appointed, judge, if a chairperson is to be reappointed, secretary of the ministry under which tribunal is set up. There should be a search and selection committee. What will this search and selection committee do? It will search for the members who are to be appointed to these tribunals. It will search for those chairpersons who are to be appointed to these tribunals. It will select them. Chief Justice of India or a judge nominated by him will be member number 1. 2 secretaries appointed by the central government. These will be other members. If to this tribunal we have to appoint a member, for example, this tribunal is Income Tax Appellate Tribunal, the chairperson of this tribunal will also be part of this search committee if a member to this tribunal is to be appointed. But if a chairperson to this tribunal is to be appointed, the outgoing chief chairperson will also be part of this committee to select his successor. If this chairperson is to be reappointed for the same number of years again, then what will happen? You will have to also include a judge who will also be part of this committee to see whether this chairperson should be reappointed or not. And then secretary of this ministry under which this tribunal is set up, this secretary will also be part of the search committee without voting rights. It will not have a voting right. For example, we have Film Certification Appellate Tribunal, which is under Ministry of Information and Broadcasting. So if we have to appoint a member or chairperson to this tribunal, the Secretary of Information and Broadcasting will also be part of this committee, but he will not have a voting right. These people will have the voting right. When you notice the composition of this committee, you will find that it is tilted in favor of executive. When the search committee is tilted in favor of the executive, because executive gets to appoint 2 secretaries, the executive gets to appoint part of the selection committee, it gets to appoint members where there is Chief Justice of India or a judge nominated by him, he is in a minority. Any such structure which violates primacy of judiciary is against the basic structure of the constitution. This was struck down by the court in Madras Bar Association because same selection committee was mentioned in ordinance as well, and same selection committee is now mentioned in this law as well. That's ugly. Not just this, Supreme Court had said that the minimum age should be 40. Any member, in order to be appointed, any member of this tribunal, in order to be appointed, the minimum age should be 40. The law says minimum age should be 50. Same provision which was there in ordinance was struck down. That minimum age cannot be 50, it has to be 40. Law says it will be 50. The law says the term is 4 years. For how many years do we appoint this member to our tribunal? 4 years. Supreme Court had said this should have been 5 years. Because if you give less tenure to a tribunal member, is going to come under your influence. We have to give him more time so that he does not come under the influence, so that he has more time in understanding the functioning of these tribunals. Supreme Court said in Madras Bar Association, term should be 5 years. The law says the term should be 4 years. That means same provisions which were struck down by the court have now reappeared in this law. And the worst part is, this clause in this Tribunals Reforms Act 2021. This is the search and the selection committee. What if there is a vacancy in this committee itself? That does not stop this committee from appointing members. That means this committee will not appoint members. This committee will suggest recommendations, will give its findings to the central government, and central government will issue appointment orders. Perfect. But this search and the selection committee, it will have to give names to the central government. How will they take the decision? Through voting. What if there is a vacancy in the search committee itself? What if there is no Chief Justice of India? What if the outgoing chairperson is not part of this committee? What if there are only 2 secretaries appointed by the central government who are part of this committee? Only they recommend name to the central government and those names are accepted by the central government and appointed. On this ground, there can be no challenge. Which means it may also lead to a situation where there are only 2 secretaries appointed by the central government who are part of this search committee, and this search committee recommends names to the central government. Central governments appoints those members to these tribunals who are recommended by central government secretaries. That means government recommending to the government for appointment to a tribunal, and this tribunal has to rule against the government. This violates the independence of judiciary. But this matter is challenged before the court. Jairam Ramesh has approached the court and has challenged the constitutional validity of Tribunals Reform Act 2021. What will happen to that, whether it will be struck down or not, we will have to wait and watch. But this is what a tribunal is. So if we have Supreme Court at the top, we have High Court for every state. Then we have district courts. And these district courts are also referred to as district and sessions court. And the judge who presides over this district and sessions court is known as district and sessions judge. But what is the difference between district court and sessions court? District judge and the sessions judge. When this district court is hearing civil case and when this district court is hearing a criminal case, if this district court is hearing a civil case, we call it a district court and the judge a district judge. When this court is hearing a criminal case, we call it a sessions court and the judge presiding this court is known as the sessions judge. Same individual, but when I am hearing a civil case, I am a district judge. The court is district court. When I'm hearing a criminal case, I'm the sessions judge, the sessions court. District and sessions court. District and sessions judge. You might have read that somewhere. You might have witnessed that somewhere. And these individuals are mostly appointed by the governor after conducting an examination by the State Public Service Commission. So State Public Service Commission conducts examination, judicial examinations. Those who clear this examination, they are appointed as district and sessions judge by the governor. And once you are district and sessions judge for 10 years, then you become qualified to be appointed as the judge of a high court. Clear? That is what you need to understand regarding district courts. But even below district courts, we have the Gram Nyayalayas. Supreme Court at the top, we spent a lot of time understanding Supreme Court, then High Court for every state, and then tribunals. Then below High Court, we have the district courts. District Court, High Court, and Supreme Court. These are constitutional courts created by the Constitution. But these Gram Nyayalayas are statutory courts. That means created by the law passed by the parliament. This law was passed in the year 2009, Gram Nyayalayas Act. What was the purpose? There's an old saying, if Muhammad can't go to the mountain should go to the Muhammad. If people can't approach judiciary, why can't judiciary approach the people? If we have Supreme Court for the entire country, High Court for the entire state, District Court for the entire district, can't we have court system in every village as well? That means in rural areas, for every village, we should have a court. And that court is known as the Gram Nyayalaya. But that is going to be expensive as well. How can we have one court for every village? That's going to take a lot of time. That is going to cost us a lot of money as well. Plus, in a particular village, we may not always have cases. The idea behind this Gram Nyayalayas was these will function as mobile courts. So vehicle will be given. You will have a judge inside the vehicle. You will have the secretary. You will have official of the court. And then this vehicle, which is a Gram Nyayalaya, will move from one village to another village to dispose of justice. That is what we call Gram Nyayalaya. But it has not been working effectively. Why? Because it takes a lot of money, resources to set up these Gram Nyayalayas as mobile courts in different villages in India. But it can be a beautiful experiment to try with, where these Gram Nyayalayas would initially function as mobile courts, will travel from one village to another for disposing justice. And their initial idea is to function as Lok Adalat. Function as Lok Adalat in the sense They will not charge any fee. They will hear these civilian matters. No lawyer is allowed to represent clients. That means these individuals, this mobile court, will hear your matter and ultimately give a verdict. If you're not satisfied with that verdict, then I will become a court. And once I will become a court, you can have your lawyer, present me with the evidence, then I will take the verdict, give the final order. So the primary intention of this mobile court is to give access to the justice at the grassroots level, and to initially play the role of an arbiter. For example, there is a village and there is a dispute. The dispute is on, there are some villages in India where people cannot marry the person from the same village. There's a couple, boy and the girl from the same village. They have got married, and the village wants to kill them or wants them to separate from each other. This mobile van as a Gram Nyala will come and ultimately try to persuade these people, don't do this because this is against constitution, against the law. They have the right to decide if they are adults, and there is no such restriction that you can't marry the person from the same village. If the villagers are convinced, matter is resolved. If the villagers are not convinced, then this mobile court will function like a regular court, and ultimately action will be taken against the villagers. That is what a Gram Nyala is. But we need thousands of crores of rupees to buy these vehicles so that these vehicles can be used to become mobile courts to impart justice to the villages. And that completes our discussion on judiciary. We will meet tomorrow, 6 a.m. again. We will start with elections. Yesterday, I told you that we will have this class till 11. Maybe we will have the class till 12. I'm sorry, but I don't want to rush things. Otherwise, there was no need for me to take the class today and tomorrow. I would simply have skipped topics, given the random content, which would not justify my conscience. If you can't attend the full class, watch it half. Recording is available. You can cover the remaining half day after tomorrow, whenever you want. But please let me take the class from tomorrow, from 6 a.m. to 12 p.m. We will cover a significant portion of election. Then we will meet again on Monday at 6 o'clock. I will take 1 more hour to finish elections. Then we will look at the previous year's question papers. Then for the last 1 hour, I will take your questions. And whatever doubts you have, just shoot those doubts to me and we will resolve them. Okay? Yes, Juhi Chawla 5G case. She filed a petition before the court saying 5G should not be allowed, 5G trials should not be allowed because it impacts with the mind. It is not conducive. It is this, and that. Ultimately, cost was imposed on Juhi Chawla. Don't come to us with these unscientific petitions. Civil services chapter would be discussed in governance, role of civil services in democracy. That's we cover in governance. Shreyas, sir, when 64th Amendment bill was tried to constitutionalize PRIs was rejected by the Rajya Sabha citing centralization of federal system, then how was 73rd Amendment passed in just span of 4 years? Because previously, under Rajiv Gandhi's government, the bill had a provision. It wanted Parliament to create local government, Panchayati Raj institutions and municipalities. Parliament, that means the center. In 73rd Amendment and 74th Amendment, it's not the Parliament which creates these institutions. It's the state legislature which creates Panchayati Raj and municipalities. That is concession number one. Previously, the Rajiv Gandhi's bill was all these provisions that we are mentioning, it is mandatory. That means you have to give them powers. Now it is made optional. You may or you may not. It is advisable that when you make this law, please include all the provisions, but mandatory provisions you have to include, voluntary provisions is up to you. So some give and take, some concession was given. Ultimately, states also realized that yes, it is the need of the hour. We have to implement directive principle. That's how through give and take this bill was passed. What is International Court of Justice? That is based in Hague. Uh, that is between the countries if they have a dispute. That dispute is resolved by the International Court of Justice. For example, on Kulbhushan Jadhav, there is one United Nations convention called United Nations Convention on Consular Relations or Geneva Convention on Consular Access. If I'm an Indian, I am arrested in Pakistan. It is my right that I have to speak to the officers of Indian Embassy in Islamabad. That means Indian government will send some officers of the embassy to meet me so that I can tell them that I was wrongly arrested, I was detained like this. That means this access is to be given to me. That's my right under Geneva Convention, under the Vienna Convention. What if Pakistan denies this access to the consular members to Kulbhushan Jadhav? Approach the International Court of Justice. International Court of Justice ordered that Pakistan should give consular access to Kulbhushan Jadhav. Okay, that is it for today. Thank you so much for staying with me. Come back tomorrow. We'll have a fascinating discussion on elections. I will tell you whom to vote for in 2024. If for that you want to attend the class, see you tomorrow, 6 o'clock, then on Monday at 6 o'clock, and hopefully we will be able to complete elections chapter. Thank you. Have a great day ahead. Bye-bye.